PHRA is very proud to be your guide to understanding the legal landscape that affects your organization. Today, we hope that you will gain an insider's look at the current public policy issues that impact the workplace. When you ensure that you're operating in compliance with legislative regulations, you're creating a better workplace by protecting not only your employer, but also your entire staff. Today, we will kick off our Employment Law Month with the COVID vaccine, identifying and handling the legal and practical implications by Mario Berdonia from Clark Hill. So Mario, as I mentioned, is a member at Clark Hill's Labor and Employment Practice Group, partnering with employers in Pennsylvania, West Virginia, and elsewhere on the front end to keep them in legal compliance with labor and employment laws, and on the back end if they need strong, experienced litigation advocate. For almost 25 years, Mario has represented employers in sectors like the healthcare, energy, hospitality, manufacturing, education, and others, helping with HR employment, counseling, labor management relations, employee litigation, wage and hour, sexual harassment, policy development, and much more. Mario's wealth of skill and experience in the labor and employment arena has been regularly recognized by his clients and the legal community. He has been named a super lawyer 3 times and recognized as the best lawyer in America continuously since 2016. And we are also very fortunate to have Mario as a board member at the PHRA. So without further ado, I would like to turn it over to Mario. Enjoy the workshop.
Thanks, Liz. I appreciate that. The pleasure is mine, being a board member, and good morning, everyone. Glad you could be with us here this morning and with the PHRA as we kick off Employment Law Month, which we're doing this year virtually, of course, spreading this out a little bit. So I hope to get things rocking and rolling on this very timely topic. As we continue to deal with COVID and the pandemic. It is December now, so there's some things that are making us start to feel normal, maybe, as we begin to talk about a vaccine, right? It's snowing outside, okay, that's normal. We had Thanksgiving, hopefully we had turkey. I don't know about you all, I'm trying to hold on to some of these things as a bridge toward where I hope we can eventually go with this leading into 2021. So let's get going here and talking about the legal and practical implications of the COVID vaccine and with our, kind of have our roadmap, if you will. I'm trying to get our slides to move here, but they're not moving for whatever reason. All right. Now, give me a second, if you don't mind. I apologize. Let me back this out. These were advancing earlier this morning. I don't know why they're not doing it right now. All right, Liz, maybe you can help with this. Maybe, are you able to put it up?
I was just gonna say, I will, you go ahead and start running through your stuff and I will get it up on my side.
Yeah, okay, I don't know why it's not, it was advancing earlier. I don't know why it's not doing that now. Let me get out of, I can just do it this way.
Liz, I would be happy to get those pulled up. It's downloading right now.
I can try it the old-fashioned way. I mean, I can do it this way. And it's not doing it. Yeah, we can do it this way. We'll just do it this way? Whatever you want to do. We'll just go through it this way.
Whatever is easiest for you.
It's fine. It's a little smaller, but we'll just go through it this way. All right, so here's our roadmap, okay? I've titled this Roadmap to Inoculation, creative, not creative, but it's something to get us going. It's just basically our outline of what I'm going to talk about today. I'm going to give you some background on where the vaccine is, talk about relevant legal principles that are applicable in this area, okay? And then I'm going to talk about key issues.
Okay, honey.
Whether there's, whether it's...
I'll need you to monitor.
Whether it's required or voluntary, we're going to talk about that. That's the big one, okay? We'll talk about alternatives when you think about whether to require this vaccine or not. If you're not going to do it, what else can you do if you're interested in trying to, of course, evaluate worker safety as it relates to the vaccine. We're going to talk about how you handle objections as an employer. And we're going to talk about some other considerations too. There are a bunch of kind of other things at the end in terms of liability and logistics, dealing with labor unions, lots of those things. Okay, so that's how we're going to get through it. So, all right, so let's talk background on the vaccine. So I'm sure most of you or all of you are already aware of somewhat of what's going on out there right now. I mean, there have been, ever since, COVID hit the mainstream, I mean, there have been vaccines in development almost right off the hop since the spring. And the government, our administration in the White House has kind of helped try to propel this forward through an initiative that they have maybe not so creatively described as Operation Warp Speed, if you can imagine that. Okay, OWS. And, that's been a process and a program where they have helped fund some of the development of the vaccines from the companies that are working on them. It's also been a process where the manufacturers of these vaccines have been working on producing them even before approval. Okay, so they can roll out quicker. And that's kind of where we are now with this. We've had, just in the last week to 10 days since these slides were completed, I mean, we've had several of them or complete the final phase 3 clinical trials. And a couple you might have heard about: Pfizer's vaccine, Moderna's vaccine. Recently, they've released some interim results on those where had about, combined between them, about 75,000 or so total participants in them. And the reports are that they've been pretty effective, 90 to 95% in breaking up, and how the vaccine has actually worked or not worked compared to, the group that's, been given the placebo on the one hand, the group that's been administered the vaccine on the other. They've been pretty promising. And those groups, Pfizer already, as of about a week ago, this was right before the Thanksgiving holiday, and I think Moderna, even as of yesterday, they've already applied now for emergency use authorization from the FDA. And so the FDA is cranking on this. The CDC is also involved. They have an advisory committee meeting today to issue some recommendations. They're not binding, but to issue some recommendations on priority groups as to who they believe should be administered the vaccine first. But the FDA is expected to approve these. Their common threshold for granting emergency use authorization is to have sufficient evidence that the vaccine is 50% effective. Okay, and again, the reports have been that the results are well past that. So I would expect emergency authorization to come from the FDA on these even within the next few weeks. I mean, they're dealing with a lot of different issues involved with distributing the vaccine. You can see some of those variables on this slide here in terms of, funding and coverage and the supply chain, if you will. That's shaping up to be one that's maybe going to play a bigger role than people think. But they're dealing with a lot of these issues, but they're already planning on right now rough distribution of that within, distribution meaning starting to ship it out even within 24 hours of the FDA's emergency use authorization. So we're looking at arguably a couple weeks at this point, okay, at least for the Pfizer one and maybe the Moderna one toward the very end of the year, early 2021. And this slide kind of talks a little bit about that timing and the phase rollout where they're going to try and administer the vaccine per capita. Okay, they're going to look to do that by state population initially while they start to continue production going forward. I mean, I think they expect initially maybe about 20 million doses of this within the first month or so. And as I said, the CDC is meeting to kind of make some recommendations to the states on how they do it. But these decisions are going to be made ultimately by state governors. Okay, that's how it's going to be parsed out at the state level. And I'm sure those governors are going to take, Pennsylvania is almost assuredly will take some input from the State Department of Health. And they're going to administer it that way, whether it be to first responders initially, which is probably what's most likely and expected, so those in the healthcare sector, people who, of course, are ill with COVID, and, then take it from there on down the line. So there's a lot going to be happening there in the next several weeks but that's what we're looking at. And even if, even if the FDA grants the emergency use authorization as expected, and starts to release this, it's going to take, they're going to require, just so you know how they do this, the FDA requires continuing data to be reported even after the vaccine is out. So, hopefully that will resolve some of the questions that are likely to remain up front. Whether it's effective just on mild or strong cases, the data has been good in that regard. Does it affect certain groups differently? Is it more effective for younger individuals or older individuals? Again, the data has been pretty decent there in terms of its universal effectiveness. One thing that I think is yet to be known and will definitely take some time is how long it will last. Okay, if you're administered it, is it kind of a forever thing? Is it 6-month thing, a year thing, 2 years? Will you need to be re-inoculated later if you do get the vaccine? That's something that's going to take some time and data to learn about. But those are some things that are going to persist even after the release of the vaccine. But this is a little bit of a synopsis, okay, of where we are. A ton has gone into this, obviously, but they're hitting the closing kick of the release of this now. So as an employer, if you haven't already been thinking about it, I think for your workplace and your workforce and to understand the legal implications, you need to, okay? And that's what we're going to talk about next. We'll talk about the relevant legal authority. And as from the title slide, there are a couple main areas here, which we're going to talk about. The EEOC, Title VII. We'll talk about OSHA a little bit as well at the end. So from the EEOC standpoint, the Equal Employment Opportunity Commission, the federal agency that enforces Title VII of the Civil Rights Act, they have, of course, released some guidance on COVID, and in particular, a very relevant question and answer document. It's called a technical assistance document, where they've answered a lot of questions for employers about, what they should do in terms of temperature checks and accommodations and things like that. But thus far, they haven't released anything specific about a COVID vaccine. And interestingly, I haven't heard that they have anything imminent in that regard, even though the vaccine seems imminent. But nevertheless, I think odds are at some point they will release something, and it probably will come in the form of additional Q&As, but they haven't done it right now. So right now what we have when we try to figure out what type of legal authority is there from the EEOC about this, we're looking back to the guidance that they released back in 2009 on pandemic preparedness, which came out in the aftermath of the H1N1. And that guidance addressed a lot of, dealing with the H1N1 virus, and in particular as it relates to the COVID vaccine. As you try to draw an analogy to that guidance talked about the influenza vaccine to some extent, okay? And that guidance did not, just for what it's worth, as we look to that, maybe for it to be instructive now, it did not bless the idea of a universal, vaccine for all employees without exceptions. It didn't do that. The position was that employers could require it, but again, not universally, subject to certain accommodations if they were requested, okay? But of particular note was a statement that the commission made at that time in that guidance. You can see that at the bottom of this slide that's on your screen now, is that the commission said then that employers should consider simply encouraging their employees to get the influenza vaccine rather than requiring them to take it, which is a pretty telling position. I don't think, again, it doesn't speak literally to legality, but I think it introduces some practicalities into the equation that employers probably ought to be thinking about now as they consider whether or not a COVID vaccine and requiring that in their workforce is right as well. So we're going to talk more about that, of course, as we go forward. But that's a pretty notable comment back then, which could carry over to how they approach a COVID vaccine. So under the EEOC, when you're looking at legal standards and applicable legal requirements, the ADA is the main look at here, okay, in the world of vaccination. Legally, a vaccine is considered a medical examination, okay, under the law. And that means under the ADA that it's permissible, okay? An employer can require it if it's job related and consistent with business necessity. And of course, again, there are other considerations. We're going to talk about those, but as a threshold standpoint, that's kind of where you're starting. And of course, you look to hospitals and healthcare employers. I mean, they've led the way in this regard. They have for a long time, and many of them across the country have required people who work in close contact with patients and others to get the influenza vaccine as a condition of employment. Okay, they believe that has been job related and consistent with business necessity, and that concept has been, it's been generally accepted, I think, at least in that sector. Now, again, since the EEOC hasn't opined on this, we're spending a lot of time looking at how I should say the EEOC looked at the flu vaccine. And when we do that, if you go back, and what I mentioned is at that point, the EEOC has said, well, employers can't universally require the flu vaccine, at least without considering accommodations. Those are things that an employer must take into account. So in all likelihood, as we evaluate whether or not an employer is going to be legally permitted to require the COVID vaccine, they need to be familiar with how the accommodations work in this realm. And that's what we're going to talk about next, okay? So basically, when you're dealing with accommodations, requests for accommodations under the EEOC, they come in the form of, well, I don't believe, employer, if you want to require a COVID vaccine or an influenza vaccine, I believe I'm entitled to an exception to that or an accommodation from being required to get it because I have a disability or medical concern, okay? And that's commonly where the EEOC and the ADA comes into play. And we've had some interesting precedent in that area as in terms of, well, how far can an employee go with that? There's a Third Circuit case I mentioned on the slide here. Third Circuit is the federal appellate court, which covers Pennsylvania. But there was a case that came out a couple years ago in 2018 involving the Mount Nittany Medical Center, where an employee was asking for an accommodation to be exempt, which came in the form of a request that the employee be exempt from the employer's vaccine requirement. And that employee raised as the basis for the accommodation request that it created anxiety over the possible side effects of that vaccine. And as that proceeded through the court system, Third Circuit ultimately concluded that anxiety effectively is a disability, a mental condition, mental disability, which required accommodation. And in that instance, an exemption from the requirement that the vaccine be administered. So, not always a straightforward thing here. You have to be mindful of employees who bring these requests to you for exemptions from a vaccine, if you are going to require it, and we'll talk more about that as we move on, but you have to be aware that these requests can come. And you have to be aware that, like any accommodation process under the ADA, it's going to trigger the interactive exchange, okay, where you're going to want to have medical documentation of the employee's claimed condition. You're going to want to take a look at the essential job functions and determine whether or not the accommodation can, in fact, be granted. And if it interferes with the essential job functions, then that's not an accommodation an employer typically has to grant. You'll look at alternatives. You'll consider undue hardship. You'll be looking at whether granting that accommodation and exempting an employee from a vaccine, if you were to require it, involves significant difficulty or expense or impact on coworkers. I mean, there's a lot of considerations that you're going to look at which go into the traditional interactive process, but that's what you'd have to do as an employer. So you need to be mindful of the fact that this is the realm you're going to be in if you get a request for an accommodation, which comes in the form of someone seeking an exemption to a vaccine requirement. Okay. Remember this too, as we consider this and talk about vaccine requirements and exemptions and accommodations. The Equal Employment Opportunity Commission has already come out and said, look, COVID-19 is something which presents a direct threat to the workplace. And that phrase direct threat has meaning for those of you who don't know under the law. I mean, that too is an exemption, if you will. In other words, if an employee requests an accommodation and granting that accommodation would result in a direct threat, either to the employee himself or herself or to the rest of the workforce, then the employer may have a ground to reject that request for an accommodation. And because the EEOC has already come out and said COVID-19 presents that, it might tamper down a little bit some of the exemptions or accommodations that employees may be able to be provided if you are an employer that's going to require a vaccine. I mean, it's the twist is it's a little unusual. Usually, as I said, employers are permitted to reject proposed accommodations if implementing them causes a direct threat. Here, the question is whether the employee can be exempt from a vaccination as an accommodation, and whether that exemption causes a direct threat. It's the same concept. It just kind of flips it around a little bit. But either way, it's going to be applicable and something employers need to consider when they're faced with accommodation requests pertaining to a vaccine. Okay, so that's kind of how the law comes into play under the EEOC's purview and under the ADA. Now, the EEOC also has purview under Title VII of the Civil Rights Act of 1964. That's separate and apart from the Americans with Disabilities Act. But the Title VII process is a little different. And really, the main circumstance that arises here that employers need to be mindful of and need to be familiar of is when an employee seeks an accommodation from a vaccine requirement due to religious beliefs. Okay, because that's protected under Title VII. And so, under that, you're looking at things about whether the belief is indeed religious, is it sincerely held. Again, there can't be an undue hardship, which in the context of Title VII accommodations for religious beliefs really focuses on the idea of de minimis costs, and we'll talk about that here in a minute. But this is what also comes up, the other main area besides accommodations for medical conditions. You're talking about accommodations for religion. So those beliefs, they got to fall within traditional religious views. Okay. So we're talking about, there's been a lot of litigation about what that means. We're talking about ultimate ideas. It doesn't have a precise definition, right? But we're talking about ultimate ideas about purpose and life and death. Doesn't need to be widely practiced to be a religious belief. And it isn't something that is a social view or economic view or a political view, and it's not a personal preference. And a lot of people try to merge those together and blur them. Employers are going to have to sort that out. And a lot of times, we get involved with that process because it isn't always clear. There are a couple cases here on this next slide that drive that point home. And these cases aren't old either. We're talking about a couple from 2007, where you get a couple different results. You had a case in North Carolina where an employee refused a mandatory flu vaccine because that employee believed that bodies were a temple. Okay, and if God gave us dominion over our bodies, we believe injecting that is an affront to that belief, that religious belief. The employee was fired in that case. Okay, and brought a discrimination claim as a result of it. The employer tried to seek dismissal of that, but that dismissal was denied, which lent some support to the concept of that being a legitimate request for a religious accommodation. Meanwhile, in the Third Circuit, same year, you kind of had a little bit of the opposite take, where you had an employee who felt that one should not harm their own body. The flu vaccine may do more harm than good, so I'm objecting to it. I'm seeking an accommodation. When that went all the way up to the Third Circuit, the court said, no, that's not based on religious reasons. That's a personal medical opinion. Okay, and as a result, that accommodation request is not well held. So, but the line's thin. I mean, that's the point with this. Okay, and so it can be tricky. It's not always easy to look at. So, as you evaluate religious accommodations, when you get to this stage, here's a couple things that employers will need to look at. You're looking at 4 factors on the sincerely held end. Does the employee have a markedly consistent or inconsistent approach with the belief? Is the accommodation sought one that's likely pursued for religious reasons? Is the timing, raise it suspect if they bring that request forward? Is this the first time that the employee is ever coming to you with any request for religious reasons? If they are, that doesn't mean it's fully suspect. It's just something to think about. Is there any other basis to look at in considering whether or not the request is or is not sought for religious reasons? So, there are a lot of factors here. And the last one to keep in mind is that I think as we consider, back then as you consider influenza vaccine, even though we looked at a few cases, but as we might consider a COVID vaccine now, The undue hardship standard here is lower for the employer to prove. That means the threshold isn't as high for them to say, look, it's an undue hardship for us to grant an accommodation and deny, to grant an accommodation and allow an employee not to get a vaccine for whatever reason. And you're looking at traditional hardship impacts. So what type of workplace you have, what's the nature of the job, what type of effect is it going to have on other employee rights? Will it diminish efficiency or affect safety? That's a big one here, of course, as it relates to COVID. But the point is that the employer has a pretty low threshold there to say, look, if we were to accommodate this, it is more than a de minimis undue hardship. And as a result, we as an employer don't have to do it as a matter of law. We don't have to grant that accommodation. If we want to require the vaccine, we're within our rights to place that above this request for, religious accommodation or religious exemption. Okay, so it is a lower threshold there for employers. I think when it comes to a COVID vaccine, I think employees will have a harder time on the religious end. That doesn't mean it'll be completely out of the picture, and it doesn't mean an employer doesn't have to analyze it. They do, but I think that will be a little bit more challenging. And then lastly, just very quickly, on the legal end of things for employers to keep in mind, I mean, it's not just Title VII, it's not just ADA. I mean, you have to be mindful of other sources of law which could come into play here. OSHA is one of them. As you evaluate whether or not a vaccine is appropriate for your workplace, I mean, there's a general duty clause in OSHA that requires all employers to provide a work environment free from recognized hazards, okay, that are causing or likely to cause serious physical harm or death. COVID certainly, I think, arguably at least fits into that category. So there's kind of a general obligation there. We haven't heard a whole lot of, about OSHA in this pandemic. There's been some fines more recently, but they haven't been very active with that. On the flip side of it, they released an interpretation letter about 10 years ago or so during H1N1 where they concluded that an employee who with a medical condition who refused a vaccination because of a reasonable belief that the shot could medically impact them, they were protected from retaliation under OSHA. Okay, and arguably they might have been protected from retaliation under the ADA or Title VII too. But arguably that principle would likely apply to a COVID vaccine too. So you got to be mindful. OSHA kind of lurks in the background here when it comes to legal sources of authority on this issue, as do various state laws, which might exist and might relate to occupational safety and health generally, okay? There also are some state laws that pertain to vaccines specifically, including by industry. So those might come into play when a COVID vaccine is released. There are a lot of those that relate to healthcare. Some states, for example, will require employees to be vaccinated for the influenza vaccine, for example. New York is one of them. Massachusetts is another. There are limited exceptions there. But there are states out there who take the opposite tack, where Oregon, for example, is one of them, where employers there are forbidden to require employees to have a vaccine. So, you might have some stuff you need to look at here. Maybe not a ton of stuff, but if you're being comprehensive or, we're working with you on something like that, that's a box we're going to check about whether there are any unique state laws which involve safety vaccines, including those in particular sectors. Okay, so that's a scope of the legal issues that play when you consider this. And that's one thing. In a sense, those kind of come second. But I say that because I think the practicalities are more important, if you will, as an employer who evaluates what they're doing here. And that's why I kind of wanted to cover the legalities first, in 20 minutes or so, and then spend the rest of the time talking about practical stuff and key issues that you're dealing with. So that's what we're talking about here for the remainder of the presentation. We're going to talk about, again, the real rub of the issue, whether an employer can require this or whether it should be voluntary alternatives and handling objections. And like I said earlier, this is the real rub. This is where the rubber meets the road, if you will. There hasn't been legal authority on this yet. I kind of said that earlier. What we have to go on really relates to the influenza vaccine. And I do think that it's likely that the EEOC takes a similar position on the legalities of this whenever it is that they do so. And I believe that the likely result will be that employers will be able to mandate a COVID vaccine if they choose to do that, subject to the accommodation requests, including those that we've talked about, for medical reasons under the ADA, for religious reasons under Title VII. I think that's likely where we're headed. But the bigger question, from my point of view, from employers I've talked with, all the work that I do in this area, I think the real question is, even if you're legally required to do it, should you? Okay. And there's a lot of considerations at play, I think, for employers to think about. And we're going to talk about those. And there's a slide here, a graphic. Again, I apologize for it being a little bit smaller because of the screen sharing issue. But this graphic shows, and I can just run through it with you really quickly. This is a Gallup poll that Gallup's been running since the summer. And the last data on this that had been reported or released as of the time I did these slides was in mid-September, where every month or so, actually it looks like they were doing it more frequently, about every week, they were asking the question in a poll of if there's an FDA-approved vaccine available at no cost, would you agree to be vaccinated? And you can see the percentages went from 66 in mid-July all the way down to 50 in September as word about the vaccine went out and about its trials and success and the speed. And so it was showing a little bit of skepticism there. And I think employers need to be mindful of that when it comes to evaluating their workplace and whether or not it's something they should require. And there was another study published in the summer by a group called Nature Medicine, where they surveyed people all across the globe, about 15,000 people in total from 20 countries, and asking about acceptance of a COVID vaccine. And while the study was vast, I pulled out what I thought was a particularly important or relevant part of that, having to do with the mandation element. And the key conclusion there was that all of the respondents, regardless of their nationality, again, this wasn't just the US, but included the United States, and all of them reported that they would be less likely to accept a COVID vaccine, to view it as safe, if it were mandated by their employer. So again, there is some skepticism out there, and a healthy dose of it, about the viability of this and whether or not it should be done. Now look, poll data has limitations, okay? We should know that by now. If we don't know that, just see the elections in 2016 and 2020. So whether it's timing, size, accuracy, take it with a grain of salt. I mean, maybe those numbers are a little different more recently with the results over the last couple weeks about the reported effectiveness of these vaccines. Again, it's reported to be higher, so maybe that change it. But these things are a snapshot of views, which kind of bring together in the aggregate the perspective of people out there, and thus by extension your employees, about the safety of a vaccine, the reliability about it, about the way they view the healthcare industry. Are people in it for money? What they view and how they color government representations about the vaccine. All of those things come into play, I think, practically for an employer when you are looking at and considering whether or not we should require this or make it voluntary. And part of that equation too goes, okay, well, if we're not going to do it, maybe or in evaluating whether we should do it, maybe we should base that decision in part on what our alternatives are, okay? And those are things where you're going to consider, some of those are on this slide here, okay? Your industry, where you do business. In other words, geographically, where it's located. Are you in a hotspot? Are you in Texas, El Paso, Texas, for example? Are you in California? I mean, where are you at? This thing is affecting everyone all across the country, but still to some different degree. So what you do here in evaluating your alternatives might depend on where you are, might depend on your employee demographic. Maybe they're more at risk. Maybe they're more skeptical. A lot of things that you're looking at. What are the alternatives within the workplace practically that we may want to think about to give our employees some reassurance that we've considered that, and we are, definitely looking out for the best interest and safety of our workers. So some of those alternatives here are on this slide, okay, to talk about those. And, you can evaluate all of these even absent of a COVID vaccine mandate. But these are some of the other options that you would have if you want to evaluate whether you wish to forego or bypass requiring a COVID vaccine. So, what positions does your workplace, or I'm sorry, what positions does your workforce occupy? Is reassignment an option? Is telework an option? I mean, a lot of employers have been administering increasing telework programs since the beginning and still are to some extent. Okay, maybe that is an option where people are able to stay more isolated for the foreseeable future. Can you change duties at all? If an employee has duties that are more at risk than not, maybe you can change around their job requirements to some degree. Do you have to? Not necessarily, but as you consider this in the calculus of whether to require a vaccine, that's probably on the table. Is a leave of absence appropriate? What about requiring masks or face coverings in the workplace? A lot of employers are doing that to varying degrees based on different mandates in the state. I mean, we know where that's gone in Pennsylvania with Governor Wolf. Where we are even currently right now with that. So a lot of employers are already doing that, but these are all things which also provide some measure of protection within the workforce, which might again mitigate against a decision to require a vaccine as opposed to making it voluntary. So there's a lot of things here that employers can and should think about. No one size fits all, okay? More than one may apply, but they're all out there, and I think employers need to think about them when they're facing the decision of whether or not they want to require this. Okay. All right. Let's talk about objections for a couple minutes and handling objections. So we've already walked through some of the legal requirements. So if you get if you were to decide to require a vaccine in your workplace, you get an objection. Here are some kind of steps basically on how to handle it. They're very general because in each one of these instances, it's going to be a different situation, but you got to walk through, well, what rule have you established? What's your policy say about this? Again, what law applies? We talked about that in terms of you thinking about the ADA, thinking about Title VII, that is medical accommodation requests, religious accommodation requests, thinking about OSHA or other state law that might govern on objections and whether or not any that are brought to you can be validly held. But you go through that, you walk through all those steps. You stick with the basics, if you will. Are there alternatives? Okay, we talked about those. And in the end, what about discipline or termination? Okay, I mean, those are considerations too. I hopped over a slide, but we can go back to it. But again, you're following through all these steps. You're walking through it all, accommodations, interactive process, and you get through all this, and then you may be left to make a decision, okay, about what we want to do in a situation. What doors do we want to open in terms of exceptions? Maybe an employee doesn't have a medical accommodation request or a religious one. Maybe they just don't like it, don't want it. They're not comfortable with it. Do you have to allow that? Can you exempt them? I mean, you can. Do you want to open that door? Do you want to create that slippery slope? Or are there alternatives to do it? I mean, you're like any other employment decision, when you're faced with making an exception, you have to think about the big picture and what scenario that creates for you for everyone else. Okay. And in the end, maybe it comes down to discipline or termination. And I'm not suggesting it won't or shouldn't. That's a tough one. But if you're going to have a policy where you're going to require it as a condition of employment, that's going to be something that you may have to think about. Okay. And again, consistency there is important. And having walked through all those legal check boxes first, to the extent they're applicable, that's also going to be important and necessary before you make any decision like that. Okay. Keep this in mind. This is a caveat or twist, if you will, because of the skepticism that's out there about the effectiveness of vaccines, or for whatever reason, employees just as a group may not be comfortable with it. You might have groups that collectively get together, okay, and refuse to get the vaccine and complain about it. And let's be clear about this, okay? the activity of engaging collectively with each other may be protected concerted activity under the National Labor Relations Act because it's group activity. It relates to terms and conditions of employment. And one thing you got to be mindful of is as we move into the latter stages of 2021, the National Labor Relations Board is likely to shift its priorities based on having a majority of appointees that by that point would be Democratic. And so once again, the NLRB is going to flip-flop several of its rulings, but they're going to take a more employee-friendly position. So by the time some of these issues reach the board, the results might be employee favorable, okay? But let me be clear about this. Just because you have employees that get together and refuse, and the act of getting together might be protected, that doesn't mean you can't discipline them if you require the vaccine. What I'm saying is that employees doing that could create a little bit of an additional kind of enforcement headache, because if you discipline them for violating your policy or your requirement as a condition of employment to get a vaccine, you can do that and that's legitimate, but the employees could just as well turn around and say, we banded together, we complained, and that's why you fired us or you separated our employment, okay? And that's where then you just have to be able to back up the reason, but could get a little sticky in there. But just because they get together as a group and complain about any vaccine requirement doesn't mean you still can't require it, okay? But again, a little tricky in there at times. So something to be mindful of that you may see given some of the skepticism that is out there about the vaccine. Okay, let's talk about other considerations for 5 or 10 minutes here, and then I'll talk about some questions because I think some have come into the chat box. So other things for employers to think about. There's a lot here on the table, everyone. This is not an easy thing, and I think it's as much practical as it is legal. We've talked about both so far, but and it's not going to be one size fits all for every employer. So here are some other things to think about. Liability here can cut both ways. Employers will ask themselves, and they get worried, well, if we don't require the vaccine, can we be liable to employees in our workplace if they get exposed at work to COVID? I mean, the answer could be yes. There's a lot of there are a lot of laws out there across the country that have been passed granting some immunity to employers for suit for COVID-related reasons. There was word yesterday that Governor Wolf vetoed such a bill in Pennsylvania that had been passed by the General Assembly, I think earlier in November. But that hit his desk, and on the last day he decided to veto that. So there isn't any, there's immunity for individuals in the healthcare field in Pennsylvania. That came out initially with one of Governor Wolf's executive orders. But on a bigger picture, as it relates to employers, there isn't immunity from exposure legally on a broad level. So an employer who doesn't require the COVID vaccine could potentially be in danger if an employee of theirs acquires the virus at work. Again, none of these situations have kind of played out yet fully in the court system, but there is a risk there. Now, on the other flip side of the coin, this is a risk that employers tend to see more closely. Well, what if we do require this and an employee has a negative medical consequence as a result? Even if they didn't request an accommodation to be exempt from the vaccine, they just had a negative medical result unknowingly. As an employer, are you responsible legally for the complications of that? Potentially, yes. I mean, that is out there. Again, it hasn't played out yet, so we don't have a long history of what that would be like. But I think that would fall under workers' compensation, and arguably there could be coverage for that. So there could be some responsibility to the employer there, even if they do require it, and there's a negative outcome. So what do you do, right? It's just a couple other things to put on the fire that makes this more challenging. One point I wanted to raise in this area, though, keep in mind, I said earlier that the Occupational Safety and Health Administration at the federal level has been quiet, or quieter than you might think in this situation. They have refused to issue a temporary rule which would mandate safety measures in the workplace related to COVID. Most of what OSHA has put out has been advisory guidance related to COVID rather than a requirement. That agency has been under a lot of criticism for that. Under the new administration, assuming that's where we're going, and I feel pretty good about the likelihood of that happening. Assuming we get a new administration in January, I think one of the first things that's going to happen is there's going to be an appointed deputy director under OSHA, and they are going to issue an emergency rule, temporary rule that relates to COVID. And by then it could cover the vaccine too. I don't know where that's going to go exactly, but that's something to be mindful of going forward as we relate to this. OSHA, I think, is going to shift a little bit in terms of what we start to get from it from employers. Okay, some other things here. If you do require a COVID vaccine, which one do you require? I talked earlier about the ones that are in the final stage process seeking emergency authorization from the FDA, from Pfizer and Moderna. There will be others probably in time. There's a third one out there as well that has passed the final stage, and the FDA is going to be considering soon. Others are likely to follow in 2021. Which one will you require? Will you permit different ones? Those are valid questions. There's not a right or wrong answer with that if you are going to require one. Other questions that come up, will you require it throughout your organization everywhere you do business? Or will there be exceptions to that based on geographic location? We talked about that earlier, right? Might there be some, hot spots, if you will, throughout the country where maybe you don't want to, where you do want to require it, but you don't want to have it necessarily in other places? That's slippery and not easy. I understand why an employer may want to do that, but you got to think about the big picture there in terms of how your workforce is going to look at that across the country or across different states or areas. Will you bear the cost of a vaccine if you require it or have your employees do it? I think generally speaking, if employers are going to require it, they probably should pay the cost. I don't think that's an uncommon approach to take. And how long will it last or be effective anyway? I talked about that earlier, right? There are some unknowns and uncertainties about that, even if you were to require it. And so that's something that as an employer, you would need to continue to track and be mindful of, to stay up on reported data about it and results that come after the vaccine is being administered. So some things we don't always have the answers to there, but those are things which employers, I think, need to consider. Again, just additional things to put on the pile. All right, a couple other things. What if you have a union in your workplace? You have a collective bargaining agreement. In that situation, you have still yet another layer to deal with. I believe pretty confidently that administration are requiring a COVID vaccine in a unionized workplace or to bargaining unit employees is almost assuredly something that should be bargained, okay, as a term or condition of employment. There might be rare exceptions where the employer has reserved the right to be able to do something like that, but again, it's generally viewed as a medical exam, and I think that's something that you're going to need as an employer. If you have a union, you're going to need to sit down and talk with the union about, and that may pose some additional obstacles for you or hurdles due to resistance and other things. But I think implementing that unilaterally in a union environment would be dangerous. And again, it's a case-by-case situation, something that you should probably consult your legal counsel about. But you got to be mindful of that, okay, if you have such an environment. What about incentivizing employees to take it? Because we spent a lot of time this morning talking about requiring it and whether you should do that as an employer. But even if you don't, I think you need to appreciate the fact that some of your employees are probably going to take it on their own eventually, maybe not right away, but some employees want the vaccine. And they're going to eventually, as more doses come out into the public and we're beyond simply first responders for those not in the healthcare field or elsewhere, it is ultimately going to start to become more available. So some employees may get it on their own. But for those who don't or who are resistant, or if you're going to have a requirement, do you want to, or you're not going to have a requirement, do you still want to incentivize it? And, do it by way of a wellness program, for example. So I can't, I could talk for many minutes about this, but let's just try and do it briefly. Over the last half a dozen years, probably 6 to 8 years, there's been a good bit of movement legally in the area of wellness programs and regulation under them. And It's been in flux and it remains in flux. As of maybe 4 years ago or so, we finally got to the point of some finalized regulations that the EEOC put out when it came to financially incentivizing wellness initiatives. And you were only allowed to do them up to a certain threshold, or else they ended up being compulsory. And thus they were unlawful under the ADA, because you can't, you can't sort of automatically mandate those incentives, generally speaking. Okay. And when those regulations came out, there was litigation that led to portions of the rule being rejected. And while some of it was upheld, the EEOC voluntarily withdrew what was left and said, look, new regulations are coming in this area. So after the equivalent of 3 or 4 years of initially getting them finalized, going through legal challenges relating to them, having some of them be official, then pulling them, we're back to kind of square one when it comes to wellness incentives. And so the EEOC is going to be working on this, I think, ultimately in 2021 at some point. Whether or not that touches upon the vaccine specifically, if you wish to incentivize your employees to take it as a part of a wellness program, that remains to be seen. But that's something to track and watch, okay, going forward, if that's a consideration for you. By the time the EEOC gets around to that, a lot of the vaccine could really end up in the rearview mirror, but we'll see where they go with that in 2021. All right, a couple final considerations before we can take some questions and go through the chat. I talked earlier about the skepticism about vaccines, okay? And so you have, like so many things these days that are increasingly politically charged, you got to be mindful of that when it comes to the vaccine too. And you have to be aware of possible instances of harassment in the workplace related to the vaccine, taking it or not taking it. So whether you require it or not, once it's out there, you might get some coworkers who are, put it in plain English, kind of hating on some others or harassing on some others for taking it or not taking it because it differs from the beliefs of the harasser. I don't think this is going to be overwhelmingly likely, but again, in our climate, you can't rule it out. And as an employer, you have to be, I think, mindful of that process. And if you do get any complaints about that, I think you need to address them, because there can be connections to legal protections, particularly of those who refuse to get it, maybe for medical reasons or otherwise. I think it's going to start with what you as an employer decide from a policy standpoint, but just be mindful of that going on in your workplace. Okay. And then lastly, consider communications and your messaging related to this. Okay. And that's what, particularly if you're going to require it, but whether you require it or not, think about that and maybe explaining to your employees what you're doing. If you've decided to do it, why? If you haven't, why? If you have such a program, what are the details of that? And, outline the process for them so they know how to seek an exemption. Maybe make someone in charge of that specifically within your HR department, for instance. Keep records, and documentation about requests for exemptions, documentation of the vaccine being administered if you do require it, those types of things, okay? So consider your messaging, communications, your HR basics, record keeping, documentation, all those things come into the picture here. So there's a whole lot on the table with this issue, and it is a big issue right now, specifically going forward. Not a one-size-fits-all answer, like I said earlier, but at least having thought through many of these variables as an employer, I think you'll be better off. That was the point here, is to put together a presentation on this which covered it. There's a good bit of articles out there, but not as many presentations about this. So we wanted to kind of give you a little bit more of an interactive, on some of these issues. Okay, so let me go through the chat a little bit, and you can continue to add some questions there. Try to go through these for 5 minutes or so, and we can keep going if it persists past that. So. And I don't know if everyone can see the chat. I think everyone can. So I'll kind of go through these from the beginning. The first was to ask whether it would be acceptable to have a policy that allows vaccinated employees to enter the office, but any non-vaccinated employee to remain remote, for the time being or until further notice. I mean, I think if you're going to have a requirement for vaccines for those that work, yes. I mean, I do think you can do that. I think that falls into the realm of considering your alternatives, if you will. So you are, for people that are remote and are not working around others, there's presenting that same danger. I mean, that is at its core why you are administering or requiring the vaccine, to ensure safety within your workplace and among your employees from employee to employee. So if you are going to keep people remote, I do think it will be acceptable to require that only of those who are in the office, if you will, and do that. But you got to be clear about it. Set that forth again in your communications and your messaging. And I think make people aware that to the extent that they are brought back to the office in time, if that's something you're going to do, that's going to be a prerequisite for them to get back in there. Okay. So keep that in mind too, if you're going to take that approach.
Mario, I have a question. Mario,
Yes,
it's Liz. I just want to say, on the flip
Liz.
side of that, what if you have an employee that refuses to get a vaccine because they want to stay remote and they don't want to go back into the office?
It's a good question. I think you kind of handled that in a reverse order, if you will. I mean, you talk about staying remote. That means that they're already remote. That means, you've reached that decision or determination that that's something that can be done. If that can be done, I think as an employer, you want to have a necessary and sufficient reason why you'd be bringing them back. If you are,
Okay.
And it probably wouldn't just apply to them, Liz. It would apply, decisions like that about bringing people back, generally aren't made on an individual basis. They might be, but, generally you're coming up with, we're going to bring everyone back into the workplace, or we're going to bring this segment back. We feel it's safe now, et cetera, et cetera. My point is that I think you analyze that decision first by focusing on the continuation of the remote part. And if they're going to stay remote for business reasons, and they can do that, and you're not otherwise planning to bring them back, then you don't bring the vaccine question into that and complicate it unnecessarily. Address the remote part first, and then if they are going to stay remote, then you can, by extension, consistent with what I just talked about, I think you can keep them from a requirement of being vaccinated if they're going to stay out. Again, this all, yeah, no, you're welcome. I mean, there's a lot of case by case stuff. Okay, so some of the additional things that came in the chat, is the direct threat to other employees or to the business. The direct threat requirement, in the first instance, it's mainly to other employees or to the individual employee itself. Now, that's legally how you should look at it. There is kind of a secondary effect, possibly to the business as a whole. Diane asked this question. If there's a direct threat to a bunch of your employees, could that ultimately translate into a direct threat to the business? Yeah. It could, but legally, when you're analyzing the concept of direct threat, how the EEOC looks at it is simply whether or not this whole vaccine issue pertains to creating a direct threat to the employee or to other employees. That's how it's going to be as a threshold level, okay? We talked about employees in different states and handling that. A couple other questions here that have come in about the vaccine. One is, what if clients ask about vaccines for client-facing employees? That's a good question. And I think that certainly as an employer dealing with a client, I think you want to be prepared to address what your approach has been or what your policy has been without identifying any employee-specific information. I mean, certainly if you have public-facing workers, and your clients or your customers, if you will, want to know what you're doing in that regard. I mean, you can't entirely hide. There's no legal basis or practical basis you can hide under the cloak of, well, we can't tell you that. That's a consideration for employers to think about among the many others that we've discussed. How is their client base going to look at them? Will their customers be afraid to interact with them if they don't require the vaccine? And maybe questionnaires could go out in that regard, or you could be having a dialogue with your clients or customers about what they may be looking for, what their expectations are. That could factor into your decision as well. So that's a great question. Another one is, can you ask an employee if they have received the vaccine after the vaccine has come available? I believe the answer to that is going to be yes. I think the EEOC is likely to speak on that. They have done that already when it comes to just asking about a lot of things related to COVID, whether the employee has been tested for COVID, where the employee has traveled to. We've got a lot of issues with that in the summer when it comes to vacations, and now recently as it relates to Thanksgiving. I think the EOC is likely to bless that inquiry under the theory that if they don't know whether or not the employee has been vaccinated, and they're considering whether or not bringing them back into the workforce is appropriate, I think their theory would be you can ask, because if you don't and you don't have that information, you could be creating a dangerous situation to that employee's coworkers. Again, you're kind of getting into direct threat as a justification to inquire, because that's what it is. It's an inquiry in that situation. It's like any other form of medical inquiry. Again, the EOC has already talked about related to COVID. So I think it's likely to be similar there. Last question here is, are there any HIPAA concerns with having two groups of employees that effectively share medical information by way of being associated with one group or another? That's a good question. I think, are there HIPAA concerns there? I know where that question is coming from, and I understand it. I don't know that that poses a huge concern, any more so than what we've been dealing with as it relates to COVID, in terms of, well, if you learn that one of your employees has COVID and you start to do some form of contact tracing within your workplace, or you close down or segregate certain areas of the workplace because that's where the employee works or that's where they've been, maybe then employees are able to draw some conclusions on their own by way of inference, if you will, as to who's involved there. I think, Courtney, what you're getting at is similar to that in terms of employees being associated with one group or another. You may start to learn, well, who's kind of been vaccinated or who isn't, that sort of thing. And are you learning inappropriate medical information as an employer that should be protected in that situation? I don't know that that's a great danger. Certainly, if you are an employer that comes into any information about vaccination, so if you require it and you document it of your employees, you do need to, of course, keep that confidential. But I think under HIPAA, we're all cognizant of the fact that at some point that may reach a limit just based on inference and other associations which are outside of the control of the employer. Okay, fact-specific question, but a good one. And then Diane's asked something else here. Can you ask contractors through an agency if they have the vaccine? So if you're talking about sort of a temp agency, if you will, or any other form of contractor, yeah, I think you can ask if they're requiring it. I think you can do that in terms of whether or not you wish to do business from them, whether or not you wish, again, if it's a temp agency or you wish to bring employees on board from that group. Are they requiring it? Is it something that they are dictating as a mandate to their people? I do think you can inquire, kind of like we talked about earlier in terms of dealing with customers or clients. I mean, I think there's going to be discussion out there amongst those in terms of what your policies are and what you're requiring, so you can make your own decisions about whether or not you wish to go there, have those relationships, have those connections, interface with those individuals. That's going to go both ways, but I do think there can be some discussion about that, and there's likely to be. I do think that's likely to happen. So those are great questions, everyone in the chat, and I really appreciate you bringing them forward. I mean, we've gone over about 7 minutes now, and I think I want to give Liz an opportunity to. And everyone else who's bridging over the next session, I want to give you all a chance to do that. But I want to thank you for spending some time with me this morning on this key issue. My contact information is up on the last slide, and I know you guys will all have the slides available to you at the end of the program for reference as well. So if you have any questions or you think there's anything you want to run by me, I'm happy to talk with you about it, or just connect with me on Twitter or by email, say hello. Or at an upcoming PHRA function. We will at some point get back to doing those in person. And I know I look forward to that, but I welcome connecting with everybody short of that as well. So once again, thanks for spending some time with me this morning. Really appreciate your attendance and participation. Have a great Tuesday, everyone. Take care. Thanks.
Thank you so much, Mario. We appreciate you giving us your time and sharing your expertise on the COVID vaccine and helping us identify and handle all of these legal and practical implications that are coming our way. You've certainly gave us a lot to consider and a lot to digest here. So appreciate that. And thank you for staying on longer to address some questions for us.
My pleasure.
So for those of you that are here with us right now, I am going to put in the chat the code information for credits for this particular session. So the HRCI code is 537788. Again, HRCI is 537788, and the SHRM code is 20-QEYTT. Again, it's 20-QEYTT. All right, so welcome back. We're going to just jump right back in here with session 2, COVID-19 accommodation issues, the ADA, FMLA, FFCRA, and beyond with Mariah Passarelli. Mariah Passarelli is a member at Cozen O'Connor. Mariah focuses her practices on a variety of labor and employment law matters, from employment contracts to complex litigation. She has represented employers in claims under ADA, ADEA, FMLA, FLSA, NLRA, FCRA, and OSHA. She's also defended universities, hospitals, and oil and gas companies in statewide class and collective actions. Mariah also counsels and companies on litigation avoidance, anti-discrimination, anti-bullying, and she reviews and drafts employee handbooks and personnel policies. Mariah also provides companies with employee training on an extensive list of topics, and we also had the opportunity to have Mariah sit on our board a year ago or so. So we're glad to have Mariah around and to continue to support the PHRA. So welcome, Mariah.
Thanks, Liz. Good morning, everybody. I hope everyone's doing well. It's snowy and looks beautiful, so I hope everybody's had a nice Thanksgiving and is excited to be here today. I know that I am for sure. So today we're going to talk about accommodations issues that are impacted by the COVID-19 pandemic. Hang on. All right. As we move through the various stages of the pandemic, certainly at the inception, when none of us really knew what we were doing, frankly, myself included, the landscape of advice for employers looked a lot different than it does now. But now, instead of concerns related to how do we put people on remote work, what does it look like if we can't, sort of those early pandemic hurdles, have at least for the most part now been crossed. At least we have some experience with addressing those issues. Now we're into a new world of face coverings and returning people to work and the vaccination issues that Mario talked about in the last presentation. So the pandemic and the challenges that it poses to employers, separate and apart from the challenges it imposes on all of us as individuals, is going to continue to ebb and flow. In some instances, we have concrete federal law that will be our guide, and we'll talk about that today in our presentation. In other instances, what we're left with is essentially best practices, because unlike something like the Family Medical Leave Act or the Americans with Disabilities Act that was drafted and revised and has a full-fledged set of accompanying regulations, the laws related specifically to COVID were sort of written and passed in the middle of the night, very rushed, and are not as fully flushed out as these other federal laws. So we're going to talk about a combination of federal law and best practice. As always, I am more than happy to take questions. I will probably proceed through the presentation and then go back and grab the chat questions at the end. Please put them in the chat. To the extent I don't get through all of them, I'm happy to respond to you directly by email or to even schedule a phone call. So don't hesitate to ask. So when you're considering COVID-related accommodations, there's essentially 3 federal laws that are implicated. The Americans with Disabilities Act, which is going to be abbreviated today as the ADA, Family Medical Leave Act, the FMLA, and then the new one, the Family First Coronavirus Response Act, FFCRA. Because situations often involve a combination of all 3 of these laws happening at once, we're going to be discussing these as fact patterns rather than going through them sort of one law at a time. The first section of today's presentation, though, is about sort of protecting the workplace. This is preliminary. It's not a fact-based scenario, but this is sort of the highlights taken from the current EEOC guidance. The EOC issued its initial guidance called What You Should Know About the ADA, the Rehabilitation Act, and COVID-19, way back on March 18th, 2020. Obviously, very near to the beginning of workplace shutdowns related to the pandemic. That guidance has been repeatedly changed and updated, and I anticipate that it will continue to be changed and updated. I've dropped the link to the most recent version, which was issued on September 8th, 2020, so just a few months ago. And so I encourage you, as time marches on, to continuously check back to make sure that something hasn't changed in the EOC guidance. As I said, they update it pretty frequently. Based on this most recent September update, here are some sort of highlights that I think are really usable in most, if not all, workplaces. So if an employee calls off sick, can the employer ask about COVID symptoms? The answer is yes, right. So here's the other thing I guess I should say as a backdrop. You will see, if you are familiar with administering your company's compliance with the ADA, that a lot of the answers when it comes to COVID are different than the answers would be if we were talking about any other ailment. So it's important, sort of, from my perspective, to view this in context. In other words, these are the COVID rules. That's why I don't think it's smart to call them the ADA COVID rules. They are the rules related to COVID-19, and they are unique to that illness. They shouldn't be extrapolated to other, issues. For instance, if somebody called off because they had a problem related to their diabetes, you couldn't ask them about their diabetes symptoms. This is just COVID. So with that context, let's go. So if an employee calls off sick, yes, the employer should check the CDC guidance for a current list of symptoms and can inquire after whether the employee is experiencing those symptoms. So if somebody just says, I'm calling in sick, I don't feel well, normally employers would not be in a real comfort zone to ask a bunch of questions of that employee about what doesn't feel well. But now that COVID is amongst us, employers can ask questions related to the CDC's list of symptoms. Right now, they are, things like, do you have a fever? Are you coughing? Do you have trouble breathing? If based on the employee's responses, the employer is concerned that the employee might have COVID, even if the employee is not concerned that the employee has COVID, the employer can require that the employee stay home from work. We'll discuss additional steps that the employer can take with respect to folks that have or might have COVID-19 later on in the presentation. The next highlight from the guidance is, if an employee calls off sick with COVID-19 or the employer suspects an employee has it, can the employer inform coworkers? The answer here is generally no, but let me explain. So information related to an employee's symptoms and diagnosis is considered part of their confidential medical record. So in compliance with the ADA, that information can't be shared except with a public health agency. The employer can, however, inform individuals who the employer fears were exposed that the employer believes they have been in close contact with an individual who may have had COVID-19. So to put this in real practical terms, you can't say, hey, everybody, Joe has COVID-19, or Joe called off this morning with a list of symptoms that makes me worry that he has COVID-19. You should get checked out. But what you can do is say, hey, employees, we believe that you've been in close contact with somebody who might have COVID-19 or who does have COVID-19. You should get checked out. Identifying the human being that you're talking about is where the trouble comes in. Can an employer require employees to undergo temperature checks before entering the workplace? Yes, but this is an important area where you need to understand that this is unique to COVID and can't be used generally. So under ordinary circumstances, not the pandemic, a temperature check is considered a medical examination under the ADA. And the practice of requiring folks to have their temperature checked would be prohibited. So once the pandemic subsides, and it's sort of a mystery to me on how we will conclude it has subsided, but I anticipate we'll get additional EEOC guidance that says these measures are over, essentially. But once the pandemic subsides, employers have to stop checking employees' temperatures. Can an employer administer or require employees to undergo COVID-19 testing? Yes. Employers can require employees to undergo a COVID-19 test and require that they produce a negative result in order to return to the workplace. Likewise, employers can administer employee COVID-19 tests provided the tests are sufficiently reliable. I dropped a note here for you. An employer must administer the tests to all employees or all employees in a specific job category or at a specific location. I fear that we get into sort of a different type of discrimination claim risk if employers are testing only select folks. So if you have everybody basically in a particular location or in a particular job category that's not able to socially distance, that's coming into the workplace, if you're going to require a test of one of them, you need to require the test of everybody returning to the workplace. The same is true of temperature checks. If you're temperature checking people, you need to be temperature checking all the people, or at least all the people at a particular location or with a particular job category. When we cherry pick who we're temperature checking or who we're COVID testing or requiring to be COVID tested, I think we run into the risk that discriminatory lines probably, albeit inadvertent, might develop so that sort of as luck would have it, we're only testing women or we're only testing people over 40. So you need to sort of make a deliberate plan to test everybody in a particular job title or location or everybody company-wide, or to require that test of no one. Can an employer ask an employee if the employee's family members have been diagnosed with COVID-19 or COVID-related symptoms? No, because the ADA has been flexed to respond to the pandemic, but the Genetic Information Non-Discrimination Act, GINA, has not. That's not an act that we deal with very often, but quite specifically, it prevents, and this is in the EEOC guidance, an employer from asking if the employee's family members have COVID-related symptoms. But the employer can ask the employee whether the employee generally has been in contact with anybody diagnosed with COVID-19 or experiencing COVID-related symptoms. So you can't say, does your family member have it? Do your children have COVID, or has your spouse experienced COVID-related symptoms? That's not a lawful question, but you can say just generally. And for practical reasons, I think you would want the general question anyway, because as an employer, you don't really care if it's the person's family members. You care if they've had close contact. You can ask have you come in contact or close contact with anybody experiencing COVID-related symptoms? If the employee's answer is yes, the employer may prohibit the employee from returning to work without producing a negative COVID-19 test. Can an employer require an employee to undergo a COVID-19 antibody test in order to return to work? The answer there is definitively no. I think, and by the way, the EEOC gives pretty little guidance as to why the answer to this question is no, but the answer to COVID testing is yes. And the best that I can determine is that the antibody test is not particularly reliable at this point, not particularly indicative of risk or the absence of risk, since folks can have been known to get COVID-19 and then get it again some period later. So the answer to this one, though, is no. Can an employer terminate an employee for refusing to answer COVID questions or undergo a COVID test or undergo a temperature check? The answer here is a big maybe. The employer has to ask the employee for the basis of the employee's refusal. If the employee provides an explanation that's related to an ADA qualifying disability or a religious belief, then the employer has to engage in the interactive process to determine if the employee requires a reasonable accommodation and what that reasonable accommodation might be. As Mario discussed, I think the answer is the same when it comes to vaccines. If an employer is going to require all of his workforce to be vaccinated and an employee refuses, there's a big difference between the employee refusing because the employee thinks the vaccine's not reliable, or the employee refusing for political reasons or personal belief reasons other than religion. There's a difference between that sort of bucket of folks and the bucket of folks who are saying, I have a medical or religious reason why I won't get vaccinated, or I won't get tested, or I don't want to answer these questions. If you're in the religious disability related realm, the rules related to religious accommodations under Title VII and the rules related to ADA accommodations under the ADA remain intact. And so a back and forth discussion with the employee with regard to religious beliefs, or a back and forth discussion with the employee and the employee's healthcare provider with regard to ADA accommodations is warranted before the employer decides what steps to take, if any. If a reasonable accommodation can be achieved, and we're going to talk about what reasonable accommodations might look like when we're in the scenarios here in a minute, then the reasonable accommodation should be granted. And it's only if you get to the very end of no accommodations exist that you might be in a situation where termination is on the table. Can an employer require a doctor's note certifying the employee's fitness for duty following COVID-19? Yes. However, this sort of butts us all up against a real practical problem, which is when healthcare systems are overwhelmed, employers sending employees to their doctor to get notes is probably not the best idea and is probably not factually possible in some situations. So from my perspective, this is in a land of best practice. Employers should develop a system that deviates from the normal. To come back to work, you need a doctor's note. For example, an employer could permit an employee to return to work with proof of a negative COVID-19 test. I think that's a really good idea. Now that testing is more broadly available, that actually might be more practical. than the employer's, say, PCP reviewing the employee's job duties and signing off on their return to work? Would the employer accept a telephone call or an email from the employee's healthcare provider? Those are other good options, just given the functional difficulties that employees might find in seeking, return to work approval from their healthcare provider. And then in developing these alternative practices, employers can help be part of sort of the solution in taking some stress off the healthcare system rather than sending employees to their PCPs for what would normally be sort of the return to work note. Can an employer screen job applicants for COVID-19 related symptoms? Yes, as long as the employer, again, does it for all job applicants in the same job. Can an employer take a job applicant's temperature as part of the post-offer pre-employment medical examination? Again, yes. Can an employer delay the start of a job applicant due to COVID-19 related symptoms? Yes, you can delay the start. Can an employer withdraw the job offer because of the symptoms? The answer here is no, unless the job for which the applicant's being hired genuinely requires an immediate start date. So if you have an urgent, immediate need and the job applicant has COVID-19 or has COVID-related symptoms, and you can factually support the sort of good faith need for an immediate start date, you could deny that individual employment, withdraw the offer. But if you don't have a genuine need for an immediate start date, the best you can do is delay the employee's start date until their COVID has resolved. Can an employer postpone a job applicant's start date or withdraw an offer of employment because the applicant is over 65, pregnant, or otherwise vulnerable to contracting COVID-19 or related complications? The answer here is no. So that's sort of the preliminary highlights of that EEOC guidance that was revised on September 8th. I recommend again that you check it and check back at it because that guidance has been changing as more is known about the illness and as employers face more challenges in the workplace related to the pandemic. Now we're going to go through some examples that I think, certainly with my clients have been coming up, some of them from the beginning of COVID-19 and some more recently. So example number one, the employee has COVID. So employee calls in sick, reporting COVID-19 related symptoms and stating this is an or. So they call off sick saying they've got symptoms or they have COVID or they've been exposed to COVID. So what do you do in that situation? First, determine if the employee is able to work remotely based on the employee's health and the availability of remote work for the employee's job position. So this is a twofold thing. If I call and say, I've been exposed to COVID, but I'm fine, I can work remotely, but I shouldn't come in. That's a lot different than I have COVID, I'm super, super ill, and I can't work at all. If the employee is able to work remotely and remote work is available, the employee must, under the ADA, be permitted to work remotely. When everyone, and remember that the availability of remote work is different from sort of the employer's preference for remote work. At the beginning of the pandemic, when most workforces put the vast majority of their employees on remote work, I think it will be impossible if an individual is working for weeks or months at the beginning of the pandemic remotely for the employer to say they can't accommodate the need to work remotely now. If an employee has a job that genuinely can't be done remotely, it's a hands-on job, it's customer service, or it's something that literally needs to be done in the workplace, then remote work would not be available regardless of the employee's ability to do it. And so you have to sort of move on down the ADA accommodation track to find out what you might be able to do for that employee instead. So if employee is not able to work remotely and or if remote work is not available for the employee's position, you have to then consider available types of leave. Does the FFCRA apply to your company? And we're going to talk about that in a second. If yes, the time off might be partially paid. Even where the FFCRA doesn't apply, is this particular employee FMLA eligible? If yes, this time would be covered by the FMLA. That includes time for quarantine even without a diagnosis. So if an individual says, I've been exposed to COVID-19, I'm going to quarantine for 14 days, that as a best practice should be covered by the FMLA. Remember, and I give FMLA training presentations, have given them, I think, to this probably exact audience for the PHRA. Remember that hoarding FMLA time makes no practical sense. An employee gets 12 weeks of it. If they qualify for it, the company should want to give it because that's 2 weeks less that the employee can take later on. And the FMLA is an easy statute to run afoul of because it doesn't require intent. you can accidentally violate the FMLA and be just as legally liable as if you did so deliberately. So because the FMLA, even in the ordinary circumstances, covers time off for individuals to be treated and diagnosed, we believe the FMLA will view this quarantine time as a period of time for treatment and diagnosis, and that it should be covered by the FMLA, even if the FFCRA doesn't apply to your company. If the FFCRA and the FMLA do not apply, the best practice is to consider this time off as an ADA reasonable accommodation. So let's talk a little bit in more detail about the FFCRA so we can understand if it applies to you, and if it does, what that means for you. The FFCRA has really, for our purposes, two components. One is an extension of FMLA leave, and the other one is called paid sick leave, which in this presentation is going to be abbreviated as PSL. The FFCRA, as we sit here today, is only in effect through the end of this month, to December 31st. It's unknown if it will be extended. I anticipate it will either be extended or something very much like it will be passed after President-elect Biden is inaugurated. This applies to companies with less than 500 employees. If your company has less than 50 employees, you might be able to apply from exemption from the FFCRA, but the rules for applying for exemption are pretty unclear. And you should seek legal guidance about whether you can apply for that exemption, whether that exemption would apply, or whether you should, for the time being, simply comply with the FFCRA. What we know is if you have 501 employees, the FFCRA does not apply to you. There are other exceptions for employers in the healthcare industry. So if your workforce is involved in direct patient care, you might also be exempt from the FFCRA. But again, those sort of finer points require consultation with legal counsel to make sure you're safe and not just ignoring a law that otherwise applies to you. So qualifying reasons for leave related to COVID-19 under the FFCRA, there are 6 of them. If the employee is subject to a federal, state, or local quarantine or isolation order, or the employee has been advised by a healthcare provider to self-quarantine, or the employee is experiencing COVID-19 symptoms and is seeking a diagnosis, or the employee is caring for an individual subject to an order that's described above, that federal, state, or local quarantine isolation order. If an employee is caring for his or her child whose school or place of childcare is closed related to COVID-19, or if the employee is experiencing any other substantially similar condition specified by the U.S. Department of Health and Human Services. I believe that number 6 in the FFCRA was placed in the FFCRA, which passed at the very beginning of the pandemic, because it was not yet clear whether COVID-19 might sort of spawn additional health conditions. There is something called a COVID-19 syndrome. It's sort of a long form of COVID where the symptoms of the virus last well beyond the period of time where the employee is contagious. For practical purposes, I think you can use number 6 to mean if you have an employee who's suffering from the lasting effects of COVID-19, even though they are not currently infected. Note that the FFCRA's FMLA extension only applies to reason number 5, meaning if somebody is off due to childcare related issues. The remaining things, so 1, 2, 3, 4, and 6 on this slide, are covered by the paid sick leave provision of the FFCRA. So what on earth does that mean? To have this FMLA extension apply, again, this is only for folks that have a childcare reason to be off. An employee is eligible after 30 days of employment. Obviously, that's much different from the main FMLA that requires somebody to have worked for 12 months and worked a minimum of 1,250 hours in the preceding calendar year. But an employee is eligible for the FMLA extension to use for childcare purposes if they've worked for you for 30 days. They are granted in that event up to 12 weeks off, and it is partially paid. The first 2 weeks are unpaid, but an employee could use paid sick leave under the PSL provision, which I'm going to explain in a second. The second 10 weeks, you need to pay the employee 2/3 of their regular rate of pay. It's capped at $200 a day and $10,000 in total. Again, this is the FMLA extension of the FFCRA, applying only to number 5, caring for the employee's child if the employee's child school or daycare center is closed. The rest of those reasons, 1, 2, 3, 4, and 6, are covered by the paid sick leave provision in the FFCRA, the PSL. Folks are eligible for the PSL on day 1 of their employment, the very first day. The amount of leave depends upon whether the individual is employed full-time or part-time. If it's full-time, they have up to 80 hours of PSL coverage. If the employee is part-time, they get coverage for the average number of hours that they work in a 2-week period. The rate of pay is the same. It's 2/3 of the employee's regular rate, capped at $200 a day, and $2,000 in aggregate. So it's a little bit less total pay, but the way that the rate works is the same as if you were in the FMLA extension. So how do you define son or daughter, and how do you define school for the purposes of that FMLA? Son or daughter is the same as the FMLA. School is, so meaning the biological son or daughter of the employee, or somebody for whom the employee sits in loco parentis, which means in place of a parent in Latin, and that is if the employee is responsible for the child's day-to-day care or financial support. And school is elementary school or secondary school. This doesn't mean college. What if others are available at home to care for the child? So no, leave if no other suitable person is available to care for a son or daughter during the leave period, then you can have this FMLA leave. But if the employee's spouse, for instance, is available to care for the child during the school closure, then you don't need to grant that FMLA extension leave under the FFCRA. And it is appropriate to ask the employee if they're requesting time off under number 5 of the FFCRA for childcare, whether or not there is anybody else available to care for the child at home. What about when the school is closed for winter break? So this is, what about when schools are closed but not closed because of COVID? So the leave doesn't apply if the school is closed for a reason other than COVID-19. But an individual can still take the leave under the FFCRA if they demonstrate that their sort of their backup option is unavailable because of the pandemic. So practically that would be, my kids are off for 2 weeks or 3 weeks for a winter break, their school is open, but during this period of time, I was able to come to work because I had a babysitter, or I sent the kids to daycare. The babysitter can't come because of COVID-19, or the daycare center is closed because of COVID-19. Then you have an employee who's back in the FMLA extension. Can leave be taken intermittently? Yes, but only if you agree to let it be. In other words, the company can decide that the FMLA extension under the FFCRA can only be taken in block, or the company can state that it can be taken intermittently. You must make that statement in writing. If the employer doesn't state that the FMLA extension leave under the FFCRA is limited to block leave, then it defaults to permitting intermittent. Can an employee be required to provide documentation? Yep, but it's limited to these things: the employee's name, the dates for which the leave is requested, their qualifying reason, an oral or written statement from the employee describing the reasons that they're unable to work, the name of their son or daughter, the name of the school or childcare, and a statement that no one else is available for care. So you can't sort of get into an inquisition with respect to the employee's need for leave, but you can ask questions in these 7 categories. What's the impact of that paid sick leave on PTO? So paid sick leave is in addition to any other form of paid or unpaid leave provided by law, policy, or a collective bargaining agreement. An employer may not require that the 2 weeks of PSL run concurrently with any other leave, but the employer can top off the PSL cap per day by paying out PTO. In other words, if I'm taking PSL and I'm only going to get paid 2/3 of my salary up to $200, the employer can allow an employee to take PTO for the other portion to bring that employee up to 100% of their pay per day. The employer is not required to do that, but can permit it. But what is clear under the PSL provisions of the FFCRA is that the employer can't say, you must exhaust your available sick leave or vacation time or other forms of PTO while also on PSL. Best practices on documentation. This goes back to sort of that healthcare system being overwhelmed component that we talked about earlier. During times when the healthcare system is overwhelmed, it's unreasonable, potentially unsafe to require the usual medical certification from folks requesting this type of leave. You can elect to forgo this certification altogether or to allow the employee additional time to submit it. Either way, if the employee's time off is covered by the FMLA and or the FFCRA, you must provide the employee with the appropriate notification. In other words, you have to tell the employee that the employee's time off is counting against their FMLA leave balance, or is counting against their paid sick leave under the FFCRA. If the FMLA and the FFCRA don't apply, again, this is example 1, the employee's called off saying they have COVID symptoms, or they've been exposed to somebody with COVID or symptoms. it's wise to consider this time off as an ADA accommodation. So if nothing else applies, consider this ADA. Treating it as such would give the employee job protection, but would not give the employee the right to pay or benefits during the leave period. And I think for employers, you should consider developing a policy that states in writing that the company's expectations with regard to exhausting PTO, continuing benefits, and the rules regarding return to work requirements. So example 2, what if the employee doesn't have COVID or COVID symptoms, hasn't been exposed, but calls off because they are in the category of folks identified by the EEOC as vulnerable? So the EEOC has defined a category of employee as vulnerable to COVID-19. This definition has changed over time, but is currently older employees. The EEOC has done us no favor, by the way, with defining older employees. In earlier versions of the guidance, they made it clear that it was people that were 65 and older. Now they just say the words older employees, and in fact, the EEOC's current example is people over 40. It's difficult for me to give you advice that is an opposite, but I think it would be reasonable for you to understand older employees as still being in that 65 or older category. The EEOC's definition, though, understand right now, the EEOC's definition on this point is unclear. In the event, in addition to older employees, whatever that means, the EEOC is defined as vulnerable employees with medical conditions identified by the CDC as making them susceptible to COVID-19. Those are immunosuppressed conditions, and the CDC has them listed on their website. Or employees with other impacted ADA qualifying disabilities, meaning somebody whose physician says that they are particularly vulnerable because of their underlying medical condition that is an ADA qualifying disability, even if it's not been one identified by the CDC. These people are considered by the EEOC as vulnerable. So if an employee states they can't report to work in person because they fall into one of the vulnerable definitions, what do? Again, sort of step 1. Is remote work available for that employee? If so, you must grant remote work. And remember that to me, I think it will be very difficult to legally defend an employer's position that remote work isn't available if that employee was working remotely at some point during the pandemic. If remote work is genuinely not available to the employee, can a reasonable accommodation be granted to the employee that would allow them to return to work in person, but limit their exposure? So something like granting them additional PPE, a different work shift, or a different work location where they come into contact with little or no people. Are those things available to accommodate the employee? And remember, in considering these alternative accommodations, you have to do so in the interactive process with the employee and the employee's healthcare provider. The company can't decide that a vulnerable employee is going to be accommodated by giving them additional PPE, personal protective equipment, if the employee and the employee's healthcare provider don't think that that accommodation will ameliorate the concern related to the vulnerable employee's condition. The employer has to engage with the employee in the interactive process to examine these accommodations, as I just said. Remember that job transfer, which is the step we always skip, it seems, in the ADA, whether we're talking about ADA in the time of the pandemic or otherwise, must be considered before you decide that the accommodation is time off from work. So if an employee is able to work, but they say they're vulnerable and can't come to work in person, and you can't accommodate them in their current position, before you decide that time off from work is the accommodation that's left to you, you have to consider whether you could transfer that employee into another position where they could be accommodated. Remember that transfer works like this. It's transfer to an available job for which the employee qualifies and in which the employee could be accommodated. That transfer could be permanent. The transfer could be temporary. You need to begin by looking at jobs that have a similar sort of pay and rank as the employee's current job. You can't use it sort of as a punitive transfer to some undesirable position, but you have to consider transfer as an accommodation before you start talking about time off from work. If no accommodation can be made in the employee's current position and the employee cannot be accommodated by transfer, a best practice from my perspective would be to give the employee unpaid time off as a reasonable accommodation. This is difficult, and I want to identify this because the duration is unknown. So under ordinary times, if an employee needed time off from work, but the duration of the time off that the employee needed was unknown or was a moving target, that wouldn't be considered a reasonable accommodation under the ADA. It's unclear based on the ADA guidance and the EEOC guidance whether or not COVID changes that analysis. So if you wanted to be particularly aggressive, and you'd gone through all of these accommodations that we just talked about, whether the employee could be accommodated in their current job or whether they could be transferred, and you conclude that the answer to those is no, technically a vulnerable employee's need for time off from work is rather indefinite because we don't know how long the pandemic will last. And you could perhaps separate the employee safely while being legally compliant with the ADA. But to me, I don't, and we've not obviously had cases to give us guidance on this yet. In other words, the effects of the pandemic are too immature to have resulted in legal decisions that we could look to for help in deciding what the best practice is. But from my perspective, periods of time off from work as an ADA accommodation when an employee is vulnerable and can't be accommodated otherwise is the way to go here, rather than sort of a short-sighted termination. I don't think you have to make that time off from work indefinite. You know, periods of time off from work under the ADA are reasonable when they're 6 months or a year long, though. So it could be a rather long period. I think it makes sense to give employees approval to be off work if this condition applies in sort of defined increments. So employee, we're going to allow you to be off for the next 90 days, and then we're going to have you check back in. You can continue to grant those 90-day periods of leave because it's not clear whether it's really an ADA accommodation or sort of a courtesy grant of time off from work. But I think that rushing to terminate these folks has at least the potential of getting you into trouble. Whether or not you would be in trouble from an EEOC perspective as we sit here today is unclear because it's unclear in the guidance. So although employees can self-identify as vulnerable, the headline of this slide is important. How not to treat the vulnerable employees. Although employees can self-identify as vulnerable and request accommodations, it's a violation of the ADA for the employer to identify them as vulnerable. In other words, you can't call up all the pregnant ladies and the people over 65 and the folks just recovered from cancer and say, hey, I know you fit in this category, or I know you might be particularly at risk, so we don't want you to come to work. That you cannot do. Employees have to start these conversations. Employers cannot. So now example 3, the employee just doesn't want to. So this is not example 1. These are not people that have COVID or COVID symptoms or have been exposed to COVID-19. And these are not people that fit into one of the definitions of vulnerable employees. These are the folks who call and say, I don't feel safe, I don't want to come. I have a reason unrelated to one of those vulnerable categories where I think that, I can't risk it. These are employees who are saying they don't want to come to work in person for all the other reasons in the world. So if an employee states they can't report to work in person due to COVID-19, but the reason's not related to the definition of vulnerable or the illness or childcare categories we discussed as being covered by the FFCRA, what do you do? This is all in the land of best practice. None of this is legally required. The aggressive answer is if somebody just doesn't want to and they're not otherwise covered, you could terminate that employee or decide that if they continue to fail to come to work, they will be considered, absent without an excuse and apply your attendance policy essentially, which would eventually, I imagine, lead to termination. But I think instead you might want to consider a brief period of unpaid leave of absence at the company's discretion, meaning you can make that 30 days, you could make that 14 days. Again, you could make it none. This LOA, the leave of absence, should be granted to all employees who request it or none. So this is another situation where you don't want your good deed to end up in something that appears to be discriminatory on other bases. So you either do or do not want to develop a short leave of absence policy to help everyone else who doesn't fit into vulnerable or one of the FFCRA reasons to have some time off from work if they feel just for personal reasons they can't come to work. Separation of employment, again, is unlawful absent of the discriminatory criteria. So what I mean in a practical sense is this. If employees who have no valid other reason covered by the ADA or the FFCRA just don't want to come to work, then if you develop this leave of absence policy, you need to make clear that it applies only in situations where the FMLA and ADA do not. And you should grant the same length of leave to everyone. Or if your decision is, we don't have the ability as a company, and that's totally reasonable, to tolerate something like a leave of absence. So if you can't report to work and you don't have a reason covered by the ADA or the FFCRA, we're firing you. That's okay, but you have to do it every time. Deciding to fire person 1 but not fire person 3 because person 3 is a really valuable employee will inadvertently, practically inevitably, lead you to some exposure to a discrimination claim where person 1 says, I wasn't fired, or I was fired, but person 3 wasn't. And the difference between us is our gender, our race, our religion, our sexual orientation, etc. So example 4 right now is probably the thing that I am getting the most questions on, the most challenges being faced by employers right now is the issue of face coverings. So there are lots of local and state laws and company policies requiring employees to wear face coverings while they're at work. If there is a local or state law that applies to you, you should develop a policy regarding what's required and a practice for dealing with requests for exceptions to that policy, or people that just refuse to wear a face covering. I think relying on state and local guidance without developing a company policy is a mistake, because the state and local guidance doesn't really give much needed definitions and information that you would need in the workplace. So let's sort of dig into that. First, I think you need to define face coverings. What do you mean? It seems silly, but obviously people have different understandings of what a face covering needs. For example, a cloth that covers the user's mouth and nose without requiring frequent adjustments. I think you need to make clear that what you're talking about is something that would cover a user's mouth and nose that doesn't need pulled up every 5 seconds. Otherwise, you might as well not require the face covering, right? So I think that your policy needs to define what you mean. Are you going to permit face shields? The CDC and a lot of other, reputable scientific resources are saying that face shields worn alone, meaning without being in combination with a face covering, really doesn't provide a lot of protection. If you just say you're required to wear a face covering and everyone shows up with a face shield, is that going to be okay? You don't want to be in a position where you're denying the use of face shields sort of ad hoc, one employee at a time. So if you're developing a face covering policy, state yay or nay whether a face shield can be used. If it can be used, are there requirements about how the face shield must be worn or how far down on the employee's face it must go? Are you going to require that it be worn only if in combination with a cloth mask covering the employee's nose and mouth? Are you going to allow gaiters? Those are the type of face covering that's sort of worn like a scarf and then pulled up over the nose and mouth. There's been some research that suggests that gaiters don't provide the same type of protection as a cloth face covering. So those are the type of specifics you want to put in your written policy so that everyone is clear and so that HR can apply sort of the rules of the road uniformly across the workforce. The other thing you want to define in your policy is when the face covering has to be worn. Is it at all times on company property? So if somebody pulls into the parking lot and gets out of their car, the expectation is they have the face covering on for ingress and egress. Are you going to make it, if you have an employee dining area, are you going to make exceptions when the employees can obviously take their face covering off to consume food, etc.? Are you going to require only that they be worn in particular work locations where the employees might come within 6 feet of other coworkers or of members of the public? You need to define when the face covering must be worn in addition to defining what you mean by face covering. And you should define a policy for the employee to come to human resources if the employee feels they can't wear a face covering. Like all kinds of accommodations, it's dangerous when employees seek the advice of their supervisor and then supervisors are making sort of on the fly decisions with regard to face covering exceptions. I think definitively, because these requests not to wear face coverings might very well be covered by the ADA, you want that out of the hands of your managers and into the hands of HR so that some uniformity in the interactive process and in making grants or denials of requests not to wear them can be made without concern that there's managers going rogue in one direction or the other on this topic. If an employee requests release from the face coverings requirements, you have to first consider whether that request is related to an ADA qualifying disability. If yes, then you have to engage in the same interactive process as you would otherwise to determine if the request can be accommodated. Accommodations might entail permitting the employee remote work, again, if the remote work is available, permitting the employee to remove the mask during periods of time when the employee is outdoors or when the employee is 6 feet or more away from coworkers or members of the public. If an employer can't work remotely, socially distant work isn't available in their current position, again, you have to consider job transfer before you consider putting the employee off of work. Finally, if you get to sort of the end of all those accommodations and there is no accommodation to be made, you could consider time off from work as a reasonable accommodation. This goes back to that period of time would be indefinite, so technically perhaps not required under the ADA, and your company will have to make a decision about whether, based on that indefiniteness, it's going to call it a situation where the employee can't be accommodated and will be terminated, or if the employer is going to grant periods of time off as a reasonable accommodation or other forms of leaves of absence. If an employee's requests relief from the face covering requirement and it's not ADA qualifying, meaning I don't believe in face masks, not related to a medical condition, just I don't believe in them. I think face masks are political propaganda, or, you know, I come to you and say something like, I face masks make me overwhelmed, make me feel like I can't breathe. And in the course of the interactive process, there's no medical support from a healthcare provider indicating an actual qualifying disability or medical need for me not to wear them. For that category of people, you can either consider that unpaid non-ADA leave of absence, as we previously discussed, or you can terminate the employee, absent other discriminatory criteria. So again, here, you have to be firing everybody who refuses to wear face masks if they don't have an ADA covered reason, or you have to be firing nobody who refuses to wear face masks if they don't have an ADA qualifying reason. Making decisions one employee at a time gets us into the danger zone for other forms of discrimination. So here's some issues on the horizon for us to consider. You know, that FFCRA, as I mentioned at the beginning of the presentation, is set to expire on December 31st. Look for an extension or a modification. I predict lasting at least through the spring months, when we believe that vaccinations will be more broadly available. Stay updated regarding changes to local state law pertaining to in-person work and face coverings. I would also mention that I think that as vaccines become available, that EEOC guidance is liable to update related to what you can and cannot do in terms of requiring employees to be vaccinated or taking adverse employment actions against employees who refuse to be vaccinated. I expect the EEOC guidance will be updated to sort of address the vaccine-related inquiries once the vaccine is being issued to, broadly to members of the public. My firm, Cozen O'Connor, continues to update its COVID-19 task force page. So things like when the FFCRA gets extended or not, or is modified, or when the EEOC issues a new update, our summary and the key takeaways on those things can be found at that website. You could also Google COVID-19 task force and it will get you to that website. I know you guys will be getting the slides at the end of today's presentation, so that should be a live link when you do. So now I think there are some things in the chat. I'm gonna check that out and see what you might want to know from a chat perspective.
Yeah.
So it says the SHRM website offered an example of an employee waiver, a voluntary form to say, I'm sorry? Okay. I think it was just somebody not muted, so I'll continue reading this question. The SHRM website offered an example of an employee waiver, a voluntary form to say they allow the company to say who tested positive when notifying other employees of possible exposure so that the conversations can be more meaningful. What are your thoughts on that? I haven't set my eyes on the actual employee waiver, but I find by and large the SHRM website to be a reliable source. I can't think offhand, and I've, consulted it a lot I've been doing employment defense for almost 17 years. So I haven't found the SHRM website to be dead wrong legally before. I haven't seen this waiver. I think that my concern about it would be, so with that said, I think I have a couple concerns just to keep your eye on if you intend to use it. I agree that an employee waiving your ability to discuss the fact that they are who has COVID-19 in terms of trying to contact trace or in terms of trying to inform other employees, you certainly can't have those conversations, identify the employee without a waiver. Let's assume this waiver is legally sound. I think there might still be some risk because the employee doesn't have the ability to prospectively waive their ADA rights. In other words, they can't release you from events that haven't yet occurred. So if they sign a release and say, I give you permission to discuss that I'm the one who has COVID, I think it would be highly unlikely that an employee who signed a release would turn around and sue you. So I think the risk is pretty small. But from a legal standpoint, I don't think it's an ironclad defense to an ADA violation claim. The other worry I would have is more practical. It is, will the employee feel that the employee is under duress in signing the waiver? Or will the employee have happily signed the waiver, but when the employee comes back to work, they're treated like Typhoid Mary, and now they regret having signed the waiver and are very upset about the fact that everyone else knew they had COVID. You also sort of broaden the number of folks that could be alleged to have discriminated against that employee based on an ADA qualifying disability. So if the only person in the organization who knows that an employee has COVID is the HR, director, or the HR director and the employee's manager, but because the employee signed a waiver, we have broader discussions with other managers or other employees. By broadening the base of, by broadening the number of people who now know that I had COVID, when I return to work, those are all the people I can allege are discriminating against me based on disability. Whereas if you confine the number of people who knew definitively that I had COVID, the only folks I suppose I could allege were discriminating against me based on disability are the people who actually knew, the HR person and my manager. So I think those are practical worries, even if we assume the SHRM waiver is valid, and I think we can assume it. So if you're going to use it, I think you need to do so really cautiously. Make sure that the employee is signing it absolutely voluntarily. Make sure the employee has the ability to rescind that permission. So if the employee later says, listen, I want you to stop telling people, or I signed it, but now I've changed my mind, I would allow the employee to rescind. And make sure that if you're discussing the employee by name, you do so in as limited a manner as possible and based on articulable need and reasons. In other words, this doesn't become sort of a permission slip to engage in workplace gossip or to disclose this medical information needlessly. Those are my thoughts on that. I have another question. Can you require someone to return to work if they are fearful of the spouse's existing conditions? They want to work remotely because of their spouse's existing condition. That's really tricky, so let's talk about that a little bit. If an employee is not concerned about their own condition, they're concerned about the condition of someone they live with, that's not technically covered under the ADA. The employee isn't vulnerable. The employee's spouse is perhaps in the definition of vulnerable. And the ADA doesn't require it, the employer to accommodate an employee based on the employee's loved one's ADA qualifying disability. But what the ADA does is prohibit an employer from discriminating against an employee based on the employee's family member's medical condition. So I think if you are allowing remote work for other folks that fall into the vulnerable category, or you're allowing remote work for folks that just don't want to return to work for whatever reason, and this employee comes to you and says, I don't feel that I can come to work safely because my spouse or child or person I live with has a vulnerability defined by the CDC, I think a best practice would probably be to grant the remote work, not because you're legally required to, but because I think you could give rise to an ADA, it's called ADA association discrimination. It is, in non-pandemic times, I refuse to hire you because in the hiring process, you disclose that your child is critically ill. And I believe that will mean you're off work all the time, or that the medical costs of the company are really high. So I don't hire you because your kid is sick. That's the way ADA association discrimination ordinarily works. In this context, if we're granting remote work all over the place and this employee's job can be performed remotely, then I think would be hard pressed to deny a request to work remotely based on the employee's loved one having a vulnerability. If we're not granting remote work to the folks that don't fit into the ADA or FFCRA, then I think legally you can not grant it here. But I think that there is sort of I would proceed with caution on that one. So I don't think there's any other questions, but we have some time for them. Does anybody, unmute and want to go live with anything? I was concerned I wouldn't get it done. I guess I motored too quickly. Sorry, guys.
You certainly gave us all a lot to think about. You do have a very fast talking voice, but it doesn't affect the learning. We still picked up on all of your knowledge and your expertise and appreciate that tremendously.
Thanks, Liz. Yeah, I'm sorry if I was worried because it was a ton of content. If I went too fast or anybody has follow-up questions, you can get in touch with me directly through Liz. And obviously I'm happy to answer follow-up questions free of charge. So email me if you want.
Anybody have anything that they wanted to follow up with before we let Mariah go? All right, so I will be posting the credits. I'm looking for those really quick here. Okay, so for HRCI, the code is 537789. And for SHRM, it is 20-ZKU6R. So again, HRCI is 537789, and SHRM is 20-7KU6R. I'll also post them in the chat, and we'll follow up with an email. But Mariah's still there, so if anybody has any last minute things, grab her ear while you can. If not, we again just ask. So it is 10:39. We will begin sharply at 11 a.m. with our next speaker. So you have a few minutes here to just reflect on everything we learned, and we will be right back at 11. Thank you so much, Mariah. We appreciate all you do for us.
Thanks, Liz. I'll hang around until 1:45, so if anybody has a question, just let me know.
Sounds perfect. Thank you.
I realized that I had not advanced the slide to show you guys my contact information. So here you go. This is the last one. It's got my phone number and my codes and email address. So here's a question. So what about anxiety? Someone is just fearful. So I think that that is something that warrants follow-up. So anxiety and other mental health issues are certainly conditions that can be ADA covered. And so if somebody says, I'm anxious, the mask makes me anxious, or reporting to work in person makes me anxious, the next step for HR is to engage or initiate, in that case, really with the interactive process with the employee to determine if that anxiety is a medical diagnosis or not. If the employee won't go to a healthcare provider or says it's just a feeling they haven't been diagnosed or treated, and refuses to engage in the interactive process, then I think that person slides out of the ADA covered bucket and into the I don't wanna category of people. But perhaps a person who says, I'm anxious, once you engage in the interactive process with them, will actually go to their healthcare provider and show that they have a medical diagnosis that is causing them that distress. If they have a medical diagnosis of anxiety or some other mental health issue, that is ADA covered, and you have to walk down the ADA accommodations path. We've got another question. Is it okay for small businesses not to wear their masks if they do not have clients in the office? I think you have to check local and state ordinance on when you're allowed to deviate from the mask requirements, or if you have mask requirements applying to you. Assuming that there isn't a state or local law, and there's a difference, by the way, between a law and guidance. Right now in the state of Pennsylvania, what we're receiving from the health department and from Governor Wolf is guidance. It's not a legal mandate. So determine if you have a state or local entity saying words to you about masks, then determine if those words are in the form of guidance or actually a law. If they are a law, then I would say see if it gives you the answer to whether or not businesses are supposed to wear them regardless of their size, regardless of their public facing. If it's guidance, I suppose you don't have to follow guidance. You're not legally required to follow it. So I guess the answer to the small business question is check out local and state announcements, determine if they're legal mandates or guidance. If they're guidance and your company doesn't want to require masks, you don't have to. If they're legal mandates, do they include details that would allow you to definitively say yes or no on the mask issue? If they don't, my best practices recommendation is to default to wearing them. In other words, if it's a legal mandate and it's unclear on when masks are required in the workplace, I would default to requiring masks. Can you send someone home because they refuse to wear a mask? Yes. You can send them home just like you would. So that's a broad yes, but let me detail what would happen next. If you have a mask requirement and an individual refuses to wear the mask, you can send the person home while you engage in the interactive process. That's essentially the equivalent of, in a non-punitive way, I wouldn't do it really aggressively. I would approach the person and say, you're required to wear a mask. Why don't you have a mask on? If they come back with something like, I think it's political crap and I'm not wearing one, or I don't like them, something that's clearly not ADA related, you can send them home and proceed in whatever way that your company has decided you are addressing mask wearing refusals that are not ADA covered. If you have an individual, though, who after you ask them, you're required to wear a mask, why aren't you wearing one? They say, it gives me panic attacks, or I can't because I can't breathe. Then I think you need to have a gentler discussion. That is, okay, I'm going to send you home today while we figure this out together, but I'm going to follow up with you, providing you an ADA questionnaire that you'll need to take to your healthcare provider so that we can figure out if you need an exception from the mask or an accommodation from the mask requirement because of an ADA qualifying disability, and then engage in that interactive process and go down that pathway. But to be clear, you certainly can send the person home for refusing to wear a mask, as long as you're doing that for everyone who refuses to wear a mask in that particular job or job category or location. And as long as you take steps to determine if their refusal is based on a qualifying disability or potentially based on a qualifying disability, and then engaging in the interactive process from there. If the reason's not based on a qualifying disability, you can send them home and discipline them as you would for insubordination, for instance. Or treat all the days that they refuse to, tell them they can't come back to work unless they're wearing a mask or willing to wear a mask throughout the workday. And if they don't come back to work, discipline them under your attendance policy. You have some leeway to get pretty aggressive on the mask requirement, provided the individual isn't not wearing a mask because of an ADA qualifying disability. Sort of political and personal preference not to wear masks is not a legally covered category. This is 10:46, guys. I guess I will sign off. But again, there's my email address. Let me know if you need anything. I hope everyone enjoys the holiday season. Stay safe. Thank you so much.
Thank you so much, Mariah. We appreciate all you do for us. Have a great holiday season, and I'm sure I'll talk to you soon.
Yep, absolutely. Thanks, guys.
Okay.
Bye-bye.
Bye-bye. All right, welcome back, everybody. We are going to jump right in here and conclude today with our third and final session, Developments in Wage and Hour Law, with Nicholas Bell and Caitlin Matshers from Buchanan, Ingersoll, and Rooney. Nicholas is a seasoned litigator who is regularly called upon to represent business clients in a variety of complex matters. His practice intersects high-stake business litigation in complex labor and employment cases, including claims related to breach of contract and business torts, trade secrets and restrictive covenants, intellectual property protection, and a variety of class and collective actions under federal and state law. Recognized by his peers for sophisticated work on behalf of his clients, Nick was named lawyer on the fast track by the Legal Intelligencer in 2017. Nick was named lawyer, or has also been selected as Pennsylvania Super Lawyer's Rising Star every year since 2015. Caitlin's practice concentrates on complex litigation in state and federal court, specifically class and collective actions. She has significant litigation experience in a variety of industries with a focus on business disputes in the financial, energy, and construction sectors. Katie has represented clients in a number of different venues, including jury trials in state and federal court, as well as arbitration. She has also managed complex litigation and has taken and defended numerous individuals, corporate representatives, and expert dispositions. Katie maintains an active pro bono practice in connection with a collaboration with the Innocence Project. She and a team of other lawyers successfully exonerated a woman who had spent more than a decade in prison who was wrongly incarcerated. At this time, I would like to invite Caitlin and Nicholas to the stage to share their knowledge and expertise with us.
Great. Thanks, Liz. Can you hear me?
I can hear you just fine. Thank you.
Perfect. Well, thank you for that introduction. And thank you everyone who's listening in here for joining us for this Zoom call. I hope you and your families are doing well during these challenging times. As Liz mentioned, I'm Katie Matchers. I'm a labor and employment litigator. I'd say about 80% of my time is wage and hour work, and the other 20% is in other employment litigation. I'm really excited to be doing this presentation with my friend and colleague, Nick Bell. today we have a full slate for you. We're going to cover 4 topics. So let me do my first attempt at advancing a slide here. Perfect. Okay, so this is what we're going to cover today. We're going to start with litigation developments and move on to Department of Labor regulations. We already received 2 questions in advance of today's presentation, so I know that's something that people are particularly interested in, and we look forward to talking about those. Third thing we'll take on is state law developments, and fourth and finally, something that is top of mind for everyone, COVID-19 and its impact on wage and hour laws. I will be with you through the first 2 litigation developments and DOL regs, and Nick will take the lead on the latter 2. So Nick and I talked about, the thing that we lament most about Zoom presentations, and it is certainly that we don't get to engage with you either before or during or certainly after the presentation. So we're going to do as much as we can in the time that we have, and we'll have hopefully some time afterwards for any questions that you might have, but we'll also conclude by giving you our contact information, and we invite you to reach out using whatever means is best for you, phone or email, if you have questions or specific issues that you're encountering that you want to talk more about. We're happy to do that. Okay, so with that, this is the first case that we selected for you in our topic of litigation developments. So this is Viet v. Copier Victor Inc. It comes to us from the 6th Circuit. In this case, the 6th Circuit affirmed summary judgment for the employer on an overtime claim. So that in itself is not really that moving, but what is really significant about this decision is the reason that the court affirmed summary judgment. The court held the employee's testimony, the plaintiff, regarding the number of hours worked was too vague and conclusory to withstand summary judgment. So we see these cases a lot where plaintiffs come in and they allege overtime claims based on very vague allegations such as, I always worked overtime, or I worked at least 80 hours a week every week that I was employed. This Viet case suggests that those kinds of allegations may not be sufficient. And you can make those arguments at the dismissal stage. Often they are harder to win at that stage. And it looks like if Viet is any indicator of what's to come, perhaps we'll have more luck with those kinds of arguments at summary judgment. But the more significant point here, I think, is actually slightly different. Don't rely on an employee being unable to offer testimony or evidence of the hours that they might have worked in support of their overtime claim. The best practice here is to keep accurate and reliable records of the hours that each of your employees are working so that you can rebut any testimony that they might offer regarding hours worked. Extra credit, I might say, is to have a policy in place that says something like, the employee understands that they are responsible for reporting their time, and they further understand that the reports that they make of the time worked will be reflected in their pay, or that their pay will be based upon the time records that they make. Even better if the employee then signs it. Those are the kinds of things that we can then point to when defending an overtime case based only on employee testimony regarding the number of hours that they worked. All right, so the next 2 slides are gonna, sorry, I jumped ahead by 1. Okay, these next 2 slides are gonna take on arbitration, and basically for decades, employers have been trying to enforce arbitration agreements, and for good reason. Arbitration can be less expensive, it can be faster, it can be confidential. So there's lots of reasons that arbitration is a great option for employees and employers alike. This case, Bigger v. Facebook, from the 7th Circuit, held that a district court could not authorize notice of an FLSA suit to employees who are ineligible to join the suit because they signed arbitration agreements. So let me tell you how we got there, what the facts were of that specific case, and then we'll talk about kind of what that all might mean. So in this case, this Facebook case, a former client solutions manager for Facebook claimed that Facebook had misclassified her as overtime exempt in violation of the FLSA. And then the plaintiff asked the court to conditionally certify a nationwide class of all client solutions managers. Facebook opposed the request. And the basis that it used to oppose the request was that the people in the requested notice, so the people to whom notice would be sent, many of them had signed arbitration agreements. And so Facebook said, therefore, they are not proper potential plaintiffs. The court didn't buy it, the district court, that is, and it held that it was too soon to determine whether potential opt-ins had valid arbitration agreements. So it authorized notice to the entire group. Facebook took this up on appeal, and the Seventh Circuit agreed with Facebook. It reversed the district court's decision and held that Facebook should have been allowed to prove that many of the employees to whom notice would be sent had signed arbitration agreements. If Facebook could prove that, the Seventh Circuit said, then notices should not have been sent to those employees. So this case has, I think a lot of lessons here to learn. Perhaps just one is think about arbitration agreements early in your litigation and think about how you can use them. Facebook used them in a way that I would say is a bit unconventional in challenging the persons to whom notice can be sent. Usually you see contests regarding arbitration agreements come up after notice has been sent. So that's one lesson is you think about whether and how you can use them early. But the other lesson I think that Bigger is teaching us is it is potentially making it harder for plaintiffs' counsel to use the FLSA notice process to identify and connect with individuals who could pursue individual claims. So that brings us to this silly slide with the request for a second opinion on the weight showing up on the scale here. And so what we're going to talk about next is the case Abernathy v. DoorDash. This case presents a classic example of being careful what you wish for. In that case, approximately 6,000 DoorDash couriers filed individual arbitration demands with the AAA, claiming that they were misclassified as independent contractors. The cost to file an arbitration under AAA rules is $300 per employee, with the employer responsible for an additional $1,900 for each claim filed against it. In DoorDash's case, with the 6,000 couriers that filed claims, that left them on the hook for $13.2 million in filing costs alone. So before DoorDash paid a single lawyer to do anything, they had to pay the AAA $13.2 million. So I don't think that this is a reason to abandon an arbitration or class action waiver strategy. Certainly not. But I do think the Abernathy is a good lesson to make employers consider the potentially significant costs that can be associated with filing many individual arbitrations. So if you are in a business where you think it is possible that tens or hundreds or certainly thousands of individual arbitrations could be filed, you might want to consider whether it is in your best interest to continue to pursue that strategy. Okay, next up is Scott v. Chipotle from the Second Circuit. And I selected this case not just because it involved Chipotle, which I think is delicious, but also because I think it teaches us something important about the class action standard versus the standard for certification of a collective under the FLSA. So frequently before the courts, there's a state law claim, and the state law claim, the state law wage claim is going to be pursued as a class subject to Rule 23 under the federal rules or something similar under the state analog, as well as an FLSA claim to which the collective action mechanism applies. So courts not infrequently are faced with the question, is a decertification motion for purposes of the FLSA collective action mechanism the same standard as the class certification motion for the state law wage claim? Scott v. Chipotle said no. So before the court were two motions: one, to decertify the class action on the grounds that the named plaintiffs were not similarly situated to the opt-in plaintiffs, and a simultaneous motion for class certification for the state wage claims. The district court ruled in favor of the employer on both. So it granted the motion to decertify and it denied the certification motion. The Second Circuit affirmed the denial of the class certification. However, it flipped the tortilla, if you don't mind the pun, for the motion to decertify, and there it reversed. The court held that to be similarly situated means that named plaintiffs and opt-in plaintiffs are alike with regard to some material aspect of the litigation. In other words, Rule 23 does not equal or is not the same as the quote similarly situated standard under section 216B of the FLSA. The Ninth and the Third Circuits have reached similar decisions. So far we have the Second, Third, and Ninth Circuit lining up on this side. So what does this mean? Well, for Chipotle and probably for employers generally, it's both a defeat and a victory. So it's a defeat insofar as it suggests that not only is the bar very low for initial certification in FLSA classes, it is also at least lower than class certification for overcoming decertification, or for establishing rather decertification. So that is a little bit, it's a little disappointing to the extent that it suggests that collective actions need some like lower showing or lower threshold to go forward as a collective mechanism. But the flip side of that is it's a victory for employers because opt-out classes usually involve greater numbers than opt-in collectives. And what the court is saying here is that the bar is higher for class actions than it is for collective actions. So practically speaking, it might be the case that though it is easier to get a collective certified, it is actually a smaller group of people than the higher standard for class certification. Okay, next up, Fisher v. SD Protection Inc. from the Second Circuit. So anyone who settled FLSA cases probably knows that they are subject to strict court scrutiny to ensure that the terms, including the amount of attorney fees, are fair and reasonable. Most courts apply a rule of proportionality and refuse to approve fee amounts that are greater than 1/3 of the total settlement. In Fisher, the Second Circuit held that such a rule was at odds with the purpose of the FLSA. Here's how the court got there. This is just a very ordinary wage dispute brought by a $10 an hour employee. The employer, as some of you may have found yourself in this situation, settled what they thought was for essentially a negligible value, right? $25,000. Of that $25,000, $2,000 went to the named plaintiff and $23,000 went to his attorneys. So that's 92% of the total settlement proceeds. The district court rejected it, and it said that that was not proportional, and it reduced the attorney fee award to 1/3 of the total settlement amount. It went up to the Second Circuit, kind of in an odd procedural posture because it was the named plaintiff versus his lawyers at this point. But the case goes up to the Second Circuit, and the Second Circuit reversed. And it sort of said in no uncertain terms that the court can't impose terms on parties to which they didn't agree. And the fact is that the parties agreed to this, and so the court should have enforced it. So what does it mean now for the employer? Well, I think it actually might be a good thing, and here's why. Plaintiffs' attorney fees are a huge driver in settlement negotiations with employees and their counsel. So this decision might alleviate plaintiffs' counsel's fears that they will be held to 1/3 of a settlement fund. It is thus possible that it would promote settlement at smaller gross numbers. Fingers crossed, but that is a potential outcome of this one. All right, the last case I have for you is Hewitt v. Helix Energy Solutions Group. I use this sort of silly graphic because this case involves a day rate, and there's been a lot of litigation surrounding the use of a day rate for each day worked. The reason that employers use day rates, or the reason perhaps they're challenged, is because the common exemptions to overtime under the FLSA require that employee be paid on a salary basis of a certain amount. Plaintiffs' counsel have argued, and often successfully, that a day rate does not constitute a salary. So though they often challenge it, employers have historically thought that if they paid their day rate at a significant amount, sometimes approaching even $1,000 a day, so that's 2 times the weekly minimum required for FLSA exemptions, that the mere magnitude of the amount they were paying should satisfy the salary basis test. In Hewitt, the Fifth Circuit disagreed. It held that a day rate, or a flat amount paid for each day actually worked, did not satisfy the salary basis required to qualify for exemptions from overtime. So the court gave us this in the event that anyone is using a day rate. To meet the salary basis test, the salary must be 1, predetermined, 2, the employee must know the amount of his compensation for each pay period before he works, and that was the rub in Hewitt. 3, salaries cannot be calculated on a daily basis without a guaranteed minimum that bears a reasonable relationship to the amount actually worked. I think the takeaway from that one is, if you're using a day rate, do it carefully and review the regulations and consider consulting counsel. Okay, so for some reason, these little bullet points are not showing up on this slide, but it doesn't matter. So the next section that we're going to do is these Department of Labor regulations. And I'm going to start with the first 2 that I think are of greatest interest based on the questions presented prior to the presentation. So first up is the joint employer rule. So a joint employer relationship is often the basis under which a plaintiff's lawyer will pursue multiple entities, hoping that one or both or all of them will be found liable. In short, it's a way of having additional pocketbooks on the other side of the V. There's two kinds of joint employer relationships. There's a horizontal joint employer relationship, and that's when the employee has employment relationships with multiple or related employers. And there's also vertical joint employment, which is when an employee has a relationship with one employer, like a subcontractor, but performs work on behalf of another entity, like the general contractor. The DOL published a business-friendly rule clarifying when these relationships exist. So first up, for horizontal joint employment, the DOL said employers will generally be sufficiently associated if, one, there is a relationship between them to share the employee's services. Two, one employer is acting directly or indirectly in the interest of the other employer. Or three, they share control of the employee directly or indirectly by reason of the fact that one employer controls, is controlled by, or is under some control with the other employer. The new vertical joint employer rule focused exclusively on control, whether the joint employer could control the employee or putative employee. 18 state attorney generals led by New York filed suit claiming that that rule was impermissible. The federal court agreed in part. It left the horizontal rule in place, but it struck the vertical joint employer rule. So at this stage, the future of the vertical joint employer rule is unclear. But what is clear is that the absence of control over an employee is not alone sufficient to avoid joint employer liability. Courts will instead evaluate the joint employment by considering the overall economic reality of the parties' working relationships. So here's something to consider. Review your own contractual relationships with third parties, as well as the actual working relationships with those third parties and the employees to assess the risks of a joint employer relationship. The next reg is the independent contractor employee rule. Whether an individual is an employee or an independent contractor is a critical determination that faces employers frequently. The decision has significant consequences, including, but not only, for wage and hour purposes. In September, DOL announced a new rule to assist with how to determine whether a worker is an employee or an independent contractor. The new rule adopts an economic reality test that focuses on two core factors. The first is the nature and degree of the worker's control over the work, and the second is the worker's opportunity for profit or loss based on initiative or investment. These factors, according to the DOL, will help determine whether a worker is economically dependent on someone else's business or instead in business for themselves. The DOL provided 3 other guideposts that may serve to determine whether an individual is an employee versus an independent contractor, including the amount of skill required for the work, the degree of permanence of the working relationship, and whether the work is part of an integrated unit of production. So here's something to consider in light of this new rule. Review your independent contractor relationships and consider the various laws to which you are subjected. Consider applying the most restrictive of those laws. All right, and the last one that I'm going to cover today, and I'm going to be especially brief on this because I think Nick is going to talk more about the impact of COVID on wage and hour law. But I did want to mention that DOL issued what is called a field assistance bulletin regarding employers' obligations in light of the remote work environment that so many of us are finding ourselves in. DOL says that employers must use, quote, reasonable diligence in tracking remote employees' hours. While it is an employer's duty to make every effort to prevent unwanted work, the employer's duty, according to the DOL, is not so unlimited. Rather, an employer must use reasonable diligence to ensure that employees are paid for all time worked. If you haven't already considered implementing policies that require non-exempt employees to record and report all time worked each day, including self-reporting time that is not otherwise scheduled, you might want to consider doing that to help prove that you did in fact exercise reasonable diligence. All right, Nick, with that, I can turn it over and you let me know, do you want me to continue moving the slides or do you want to take it from here?
I think, I don't know if I have the ability to also manipulate the slides.
Well, I'm happy to do it if that's easier.
Yeah, if you wouldn't mind, just
Yeah.
For ease of presentation here. Well, thanks everyone for joining us today, and really a pleasure to be speaking with you about wage and hour law developments over the course of 2020, which has certainly been an active year for labor and employment attorneys like Katie and I. There have been so many changes that have transpired just non-COVID related, right? And some of those I'm going to be talking about today. But then you have, different laws, statutes, guidance, orders that have been passed all throughout the United States that impact employers and the workforce. So there's certainly a lot to cover, and we could probably spend more than an hour doing it, but I'm going to take up the next half hour roughly, discussing with you some of the state law developments that have occurred over the last year, and then some COVID-19 specific considerations with respect to wage and hour laws that we're seeing clients having to address as they begin to bring their workforce back onto the work site, and then also dealing with taking employees back into virtual, like so many folks across the country are having to do right now, given the uptick in COVID cases. So the first state law development that I wanted to discuss was California's revision of AB 5, which is now known as AB 2257. And in California, this was a landmark law that is seeking to revise and clarify independent contractor laws as they apply under the California Labor Code. This new test, which originated in a 2018 California Supreme Court decision, has been dubbed the ABC test. It was a test that was adopted from Massachusetts courts. And the test is a means for an employer to demonstrate that any given worker is an independent contractor and therefore not subject to the same wage and hour requirements that an employee would be subject to. And so all three of these elements have to be satisfied in order for the worker to be considered an independent contractor. And so first, the person has to be free from the control and direction. So this is the control element. Free from the control and direction of the hiring entity in connection with the performance of their work, both under the contract for that performance and in actual fact. And we'll discuss an example of that in a moment. The B, or the second part of the test, is the person also performs work that is outside the usual course of the hiring entity's business. And the third factor is the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So If that doesn't seem too confusing, you're ahead of the game. The three parts of this test were developed during the 2018 Dynamex decision. And Katie, if you want to advance the slide. Thank you. So this 2018 decision from the California Supreme Court really altered significantly the way in which California courts and agencies will determine whether an employee or a worker, sorry, is an independent contractor. And so very much of a narrowing and making it more difficult for employers to satisfy the requirements for a worker to be an independent contractor. And so this new law, 2257, is codifying the decision that came down in Dynamex in 2018. The Dynamex decision involved a same-day courier service, and Dynamex back in 2004, in an effort to reduce operating costs, the company converted all of their drivers to independent contractors. And Dynamex, among other things, required their workers to provide their own vehicles, pay for all of their transportation expenses, including fuel, tolls, vehicle maintenance, vehicle liability insurance, and Dynamex, the Dynamex drivers were also required to pay out of their own pocket for a Dynamex shirt and badge. And so with all of these expectations of their drivers, the drivers still had significant autonomy. Some of the drivers did work exclusively for Dynamex, including the named class plaintiffs in the Dynamex case. But their employment within the class of workers was not necessarily exclusive. And other drivers worked simultaneously for competing carriers. They were also free to set their own schedule, so long as they notified Dynamex in advance, and they had discretion to set their own delivery routes. Given all of that, the court in Dynamex found that the drivers were employees, and the court went through the three prongs of this ABC test and found it compelling that for the first prong, so the control prong, Dynamex obtained the customers for its deliveries. It set the rates that the customers would be charged. It notified the drivers where to pick up and deliver packages. It required the drivers to utilize its tracking and record keeping system. So those were significant elements of control that Dynamex exerted over its drivers to persuade the court that these workers were in fact employees. For the second prong, the delivery driver's work was substantially within the usual course of Dynamex's usual delivery business. Dynamex was in the business of delivering packages, and these drivers and the work that they were performing was substantially aligned with that business of Dynamex. And then for the last prong, there was a commonality of interest as to whether the drivers were customarily engaged in an independently established trade or business, which was the parcel delivery. And so the business of the drivers and what they were engaged in for their trade was had sufficient commonality with the business of Dynamex parcel delivery. So the court in that decision tried to distinguish between the relationship of Dynamex and its drivers with a retail store location that hires a plumber to repair a bathroom leak. So in that example, the retail store has a business that is not substantially similar to the business of the plumber who's coming in to repair a leak. That demonstrated for the court a difference between what it was in front of it at that time, which were the drivers working for Dynamex. So with this new law, effective January 1st of 2020, the AB5 part of this framework has certain exceptions for from the test, and these exceptions are subject to an older test under California state law that focuses more significantly on the control factor in the ABC test. And there are a whole host here of professions that are exempted from the ABC test, but significantly, this doesn't even necessarily scratch the surface. There are, I believe, 109 different worker types or classes that are exempted from the law. And what is notably absent from the exemptions are significant groups of workers that are in California that you might expect to be included. For example, workers in the gig economy, Uber, Lyft, DoorDash type workers, trucking industry. So you have individuals who are not exempted there. And then you also have television and movie industry workers who are also not exempt. So despite significant lobbying efforts made by businesses in those industries, they were not able to get an exemption from the test. And so therefore, those businesses will have a much more difficult time demonstrating that their workers, for example, who are driving individuals for a driver type service, Lyft, Uber, are not employees. Katie, if you want to go to the next slide. So this next state law development brings us to Georgia. And this law is effective August 5th of 2020. It is named Charlotte's Law. And the law was inspired by a public school teacher whose supervisor would not allow her to express breast milk, pump breast milk during her planned break. And the supervisor would only allow her to pump if she, during her break, if she stayed late beyond the workday to do so. And so just as a background here, this law, Charlotte's Law, that was passed in comparison to federal law under the FLSA, this is one of, if not the strictest lactation break laws in the country. And so the background here is the FLSA requires covered employers to provide reasonable unpaid break time to hourly employees to express breast milk for nursing a child up to 1 year after the child's birth. The law also requires that employers provide employees a private place that is not a bathroom for these breaks. And the FLSA's lactation break requirement doesn't apply to salaried workers. Charlotte's Law, in contrast, provides additional protections and notably applies to all private employers. Nursing mothers under Charlotte's Law are entitled to reasonable break time, to express breast milk during work hours. So that part is similar to the FLSA. Any break time must be paid at the employee's regular rate of pay. So that's a significant difference from the FLSA requirement. This break time must be paid for. Does not apply to employees working from home. So that's an interesting point here, especially in the age of COVID, where you potentially in Georgia have many employees who are working from home and may have to spend part of their time during the workday expressing breast milk. There is a hardship exception that's available for employers with fewer than 50 employees. And, you know, I imagine that there might be several applications for an exemption here, because small businesses certainly would have a more difficult time from a practical perspective to, if they are in a small space, to provide an area, a private place that is not a bathroom for these breaks in order to stay in compliance with Charlotte's Law. And interestingly, unlike the federal law, this Charlotte's Law is not limited to the first year after the birth of the child. So there is no cap. And depending on the mother's preference, this lactation break could go well beyond the first year. And so I think employers need to be mindful who have locations in Georgia to know that just up to the first year after the child's birth is not enough. And there's really no guidance within the statute or any kind of explanation as to when this time would expire. And it seems that it would be up to the mother's discretion as to when she no longer needs to take a break during the workday for lactation purposes. Katie, if you want to advance, please. So in Pennsylvania, earlier in the year, we had a decision come down from the Pennsylvania Supreme Court that narrowed the independent contractor test for unemployment compensation purposes. And again, this is making it more difficult for an employer to demonstrate that a worker is an independent contractor. To overcome the presumption in the statute in Pennsylvania that a worker is providing services for wages as an employee, the employer must show that the individual was free from the employer's direction and control. So again, we have the control element, and that the individual is customarily engaged in an independently established trade, occupation, profession, or business, such that that such individual either works for others or at least holds him or herself out as available to work for others. And the court commented, a worker can be considered an independent contractor only if he or she is in business for himself or herself. And so interestingly, this part of, sorry about that, I'm getting a call. So demonstrating that the worker is an independent contractor and showing that the individual is actually involved in an independent trade, occupation, profession, or business, simply showing that they're capable of performing services for others was not enough for the court in this instance. The court emphasized that its interpretation of the statute did not equate to actual involvement. So the individual, the court agreed with the notion that an individual can be an independent contractor who is simply satisfied with working for a single client at a single location depending on their circumstances. But that an individual must be actively holding himself or herself out as available nonetheless for business by, for example, using business cards or other forms of advertising his or her services, despite the fact that they seem to be attached to a single employer. So again, we have an example of a court making it more difficult for employers to demonstrate that workers are independent contractors. Katie, if you want to advance. So with COVID this year, there are a number of different examples of how this transformation in the workforce is impacting wage and hour decisions of employers. And there's been a number of new laws passed. We have the HRCI that is passed that is impacted employers in the way that they are handling employees who, for any number of reasons, COVID related, are taking leaves and taking absences from work. I believe Katie might have mentioned earlier in the presentation, the DOL's Wage and Hour Division has published employer guidance regarding compliance with the FLSA during the pandemic. They touch on teleworking and whether employers can mandate or require employees to telework, and that certainly is permissible. It also, the guidance goes into whether OSHA requirements are applicable to a home office environment. And of course, there you then have issues arising for workers' compensation claims that may arise in a home work environment. We've noticed that new filings, uptick in filings for cases where employees are disputing certain compensation practices related to sanitation time, hygiene time, expanded schedules, on-call time for employees that are all as a result of the way that the workday has shifted to accommodate for all of the different activities that employers now have to engage in order to remain compliant with government orders and to remain open. Some of the potential pitfalls that we've seen clients run into have been paying employees for commuting time, paying for time spent on safety-related actions, and especially here it is a critical area that I think many employers, clients have asked us about, is time spent answering a questionnaire, waiting time that is spent for getting a temperature check prior to gaining entrance or admission to the workplace. This is a real gray area, about whether employers should be paying for this wait time or the time that is taken to get a temperature reading at the workplace. And it really comes down to whether the activity is considered a preliminary or principal activity of the employee under the FLSA. And if it's not a principal activity of that employee, then if it's a preliminary activity, is it integral and indispensable to that employee's principal activities? And so if it's, for it to be integral and indispensable, it needs to be necessary to the principal work and performed or done for the benefit of the employer. And so when you have employees that are, well, let me back up. If you have an employer that, in order to remain in compliance with a government order, in order to stay open, in order to demonstrate that its employees are COVID-free, that they have a safe workplace, safe work environment, safe place for accommodating the public, it might very well be maybe not necessarily a principal activity, but preliminary activity that is integral and indispensable because that employee must be able to demonstrate that they are not COVID positive, or they do not have a fever. And so the time that is spent waiting for and then administering or receiving a temperature check could then be compensable time under the law. And so, you know, employers, if they want to be on the conservative side of things, should look at compensating employees for this kind of downtime, wait time, and temperature check time that is spent, because it could be viewed as integral and indispensable to that employee's principal activities. But something that we emphasized here at the end is it's just extremely important for the employer to get ahead of all of this and establish a policy, a back to work policy that is transparent, that is clear, or as clear as it can be to employees, so that everyone is on the same page about how these different issues are going to be treated, and the protocols that are in place, so that everyone has a clear path to follow when inevitably someone in the workplace has a positive COVID test, has a temperature read, and the like. So those are the issues that I wanted to touch upon briefly for COVID and wage and hour laws. Just in conclusion here, and I know we have a few minutes left to maybe answer some questions, but yeah, 2020 has certainly been a unique year with all of these court decisions, new DOL regulations, the changing state legislation that we've reviewed, and the COVID-19 pandemic has all impacted wage and hour laws in many different ways. We'd also note that transitioning administration could also make this an even more dynamic 2021. So just stay tuned for regulatory changes, new legislation, further guidance from the courts and from state governments in terms of what will be required and on the horizon for employers and employees in 2021. We want to thank you for taking the time to listen to us this morning, and Katie and I at Buchanan, Ingersoll, and Rooney are always actively involved in all of these subject matters and materials, and are always trying to stay on top of all the changes that have taken place and will take place in the future. So that's our contact information, and I think we have a little bit of time for questions. If Katie, I don't know if you had seen anything in the chat that you wanted to try to address first. So I'm just reading through some of these now.
Caitlin, it looks like you're muted. I didn't know if you wanted to try to address some of the questions there, or if you want me to read them, whatever works for you guys.
All right, yeah, just scrolling through here.
Okay.
So I think
Okay.
there's one question here about exempt employees considered salary employees. Salary employees are generally considered exempt. I think that answers the first part of the question, and then exempt salary employees are not subject to the same overtime requirements under the FLSA as non-exempt employees, and so I believe, yes, the answer to that question is you would be able to work more than 40 hours and pay them there, because you're only ever paying them their salary. You're not paying them by the hour.
Yeah, and we have another one regarding, it looks like an hourly employee in a small business who is not entering time worked on a timely basis. And so I'd say the starting point for this should be whatever company policy is, and there should be a company policy that says employees are required to enter their time and they must do so on a timely basis or within a certain amount of time. And if that employee is not complying with that rule, then they should be disciplined, as should all employees be disciplined. I would think that not paying them is not probably the best course. Rather, I think it's addressing sort of the root issue here, which is there is a policy and it's being violated. And so that needs to be addressed and dealt with as a matter of policy, rather than just resorting to not paying the employee.
Right, and I'll just add to that. I mean, ultimately, it's the employer's responsibility under the law to have the proper records for hours worked. And so if, I don't know how large this small business is, but generally speaking, it's the employer's responsibility to do that, even though you might pass on that activity to an employee. It's ultimately the employer that's responsible for keeping track of time worked and the records that go along with that. But I agree with Katie, if you do have an employee that's just flagrantly ignoring the policy on how to keep track of time, then that's an issue that needs to be addressed under that governing policy.
Yeah.
The temperature check, I can take this one. So this question is time spent on temperature checks. If the employer is requiring employees to arrive early so they are ready when the doors are open, the person asking the question says they feel the employees should be paid for this time they arrive early, and also the questionnaire. So again, this goes to sort of, that's the more conservative reading of the requirement for paying for preliminary activities. I mean, arguably that's not a principal activity, right? It's not something that they're doing in the ordinary course of their job duties during the workday, is to take temperature checks. So it would fall under the category of a preliminary activity. But because arguably it could be demonstrated that that preliminary activity is integral to their admission to the work site, that they have to have a temperature reading below whatever it is, whatever the state guidance is or CDC guidance, in order to gain admission to the work site, to be able to work, to be able to perform their duties. It's integral to the principal activity itself. And so in that instance, that time spent arriving early before the doors open, completing the questionnaire, that could be considered time that needs to be compensated for under the law.
Yeah, I agree. So I think that is all we have time for, but thank you everyone. And as we said when we started, certainly if you have more questions or you feel like you want to talk more about questions that were already asked, just reach out using the contact information on this slide, and we hope to hear from you.
Thank you so much, Katie and Nicholas, for rounding us out here today for our final session. The knowledge and expertise you shared certainly will go a long way with all of our member organizations. Also, thank you to all of the members that participated today. And as promised, I did put the credit information on the screen, but the HRCI code is 537790, and the SHRM code is 20-YVWPQ. So I'll give everybody back the rest of their day. Have a wonderful afternoon, and we look forward to seeing you here again on the same platform at noon for our employment law update. Have a wonderful afternoon, everybody. Thank you.
Great. Thanks, everybody.
Thank you.